210, Annexure D. Part 2.
Page 110.
210.
210.
210.
Have you entered into an agreement?
No, this is an offer letter.
This is the offer letter.
Yes, offer letter is the, my lord, highest, my lord. After, my lord, getting order, I shall enter into an agreement, or I shall sell it.
How do you say?
Unless leave is granted, I cannot enter into an agreement.
Yes. Record or not? Learned advocate for the petitioner joint receivers are present. Heard learned advocates. The hearing is concluded. Let this matter appear for orders on 3/7/2025. Yes, next one is also
Similar,
the same.
Similar.
Okay, same order. The order the same order. No, আলাদা আলাদা. Fixed item. আরে বড়টা হ্যাঁ দেখে দিন fixed itemটা.
My lord, in this matter, I am appearing on behalf of the
behalf of the
defendants.
plaintiffs.
My lord, except defendant number 10. My lord, the GA 17 is an application for expunging the name of the defendant number 6 has already been filed. But that application has yet not been appearing in the list.
Only expunging of the name.
Only expunging of the name of the defendant number 6. He has already been expired,
They are
They are-
already
they
on record.
already on record.
Anyway, that can be done at any point of time.
Yes.
Only the thing is to be rectified.
Now, my lord, GA 15, my lord, is my application, my lord, for addition of party.
GS 17 is not appearing.
Yes, GA 17 is not appearing.
Which is for expunging of the name of the dependent number 9.
6.
Dependent number 6.
Okay, let GS 17 appear tomorrow.
No, day after tomorrow. Tomorrow is my son.
Day after tomorrow, this bench may not sit. Okay.
Tomorrow I have some difficulties.
Then Thursday?
Thursday, yes.
Actually,
Let my application for addition of party be heard.
Anyway, you to
All the affidavits are complete in this application.
Let it appear for the advocate, partition commission.
learned advocates for the parties
Dependent-
are present. এই নামগুলো স্লিপে মাথার উপরে রেকর্ড করে দেবেন ওই স্লিপ গুলো নিয়ে এই ডান দিকে যে নামগুলো থাকে ওগুলো স্লিপ দেখে করে দেয় আমি শুধু লিখে দিচ্ছি লার্নেড অ্যাডভোকেট ফর দ্য parties are present as GA 17 of 2024 is to be decided. Let this matter appear along with GA 15 of 2024 and GA 16 of 2024. এটা একসাথে করে দেবেন একটা অর্ডারের মধ্যে Yes, on third it will be taken up.
My lord, the application on GA 15 may be taken up. My lord.
Yes,
That is
yes.
for a
Yes.
Yes,
addition
both
of-
will be. On 3, let this matter appear on 3/7/2024.
Because if my addition is allowed, my lord, the entire, my lord, preliminary decree has to be modified. My lord.
Anyway, both the things will be considered.
Yes, get full lords.
Will be fixed at any time.
Third.
No, in the usual courts it will appear.
My lord.
I had a GA which is GA 16. That is also appearing.
Yes, it will appear on 3rd.
Great. Time to bill.
My lord, item number 16 and 17 are my matters, my lord. The last occasion was, please direct me, serve me a copy of the other side, my lord. There was a holiday, my lord. I was.
That is GA 8.
Yes, my lord, GA 8, item number 16, GA 9, item number 17, my lord. My lord, kindly give me a direction to serve notice upon them and also give me a direction to
No, what?
serve
Let me
them.
see the application
Yes, ma'am.
and the earlier order.
My lord, I'm seeking a innocuous prayer. Give me a direction. Go to the special officer.
GA 18.
GA 8, my lord.
GA 8.
Yes, ma'am. Item number 16.
GA 8 টা দিন কোনটা এটা GA 8 হয়ে গেছে
My lord, previous one, 2317.
আচ্ছা আচ্ছা আচ্ছা। What have you prayed for in this application?
My lord, I'm seeking a direction to this special officer to disburse the amount which is lying with the register of original assent. Because shares has already been distributed and some of the portion has already been disbursed, but some portion has not been disbursed. And my lord, there was a coordinate bench order, Honorable Justice Shubhari Standard. There was a direction to appoint a special officer, new special officer, Mr. Gopal Roy. That order is with me, my lord. Page number 9, 4th paragraph. My lord, kindly give me a direction to serve a notice upon Mr. Gopal Roy because notice has not been yet served.
You are representing whom?
Applicant, intervener.
Okay. Record an order.
Teshwar Singh, Kopileshwar Singh,
Learned advocate for the applicant intervener
Yes.
is present. As service is not caused upon the learned special officer appointed in this matter, as well as upon the parties to the case. Let service be effected upon the parties as well as the special officer.
The name of the special officer now is Mr. Gopal Roy.
Yes, yes, yes. Whatever, whoever is there,
Yes, ma'am.
let the copy of the appointment of special officer by this court be also communicated to the learned special officer. Let this matter appear on 17/7/2025.
Oh,
Yes, both the cases, 16, 17.
yes, I did.
Okay.
Hello, in this matter, on the last occasion, I am appearing for the plaintiff. I mentioned the matter, what has happened, my lord, the time to file, I'm paying for extension because the person who is looking after the matter has lost his father and he has gone to his hometown. I'm paying 10 days time. Kindly
GA4 is whose application?
GA4 is my application for my lord initiation of an inquiry for perjury committed by the
But
plaintiff.
your lordship has given time to file affidavit, but
This is
this
the second
uncertain happen-
extension being
10 days,
asked for.
10 days time will give because he has
Yes,
gone.
record
My lord,
and order.
granted, my lord will kindly make it peremptory, my lord, this second
It will be
extension.
filed, my lord,
I'm
it
just-
will be filed within 10 days, my lord.
Learned advocate for the
Plaintiff.
petitioner and learned advocate for the, you are for opposite?
I'm for the defendant in the suit and the petitioner in this application. My lord, I'm the
I'm-
petitioner.
I am for the
Advocate
plaintiff
for the
and respondent.
petitioner, defendant and learned advocate for the plaintiff opposite party are present. As time is sought for to file affidavit in opposition,
Yes, my lord.
affidavit in opposition to GA4 of 2025. Such prayer is allowed. Let affidavit in opposition be filed on or before 14/7/2025.
Yes, my lord.
Reply, if any, by 18/7.
Next of the name.
My lord, will kindly give me 1 week, my lord, in case
25.
I don't want to
Okay.
ask for an extension.
21/7/2025.
Well.
Let this matter appear on 23/7/2025.
My lord, only one other prayer, my lord. There's another pending application where affidavits are complete, my lord. Both parties have already filed GA3. My lord, the records were not traceable on the last occasion. Now the records have been found. If my lord can direct GA3 to be listed any day, my lord. That, my lord, no affidavit has to be filed. It is for hearing.
The both applicants will be heard.
GA3
together.
No,
will
no.
mention on any day, it will be listed.
My lord, we'll mention
It
it
will not be taken up with this application separately.
Yes, it should be
separately.
taken,
It has
but-
to be
So
separate.
you file, mention any day, it will be taken up.
My lord, obliged.
I'm for the judgment letter, your lordship.
My lord,
19, I think hearing was concluded, only
yes,
some
my lord, we have filed our notes.
application and written notes are required to be filed.
Yes.
No, our notes have already been filed within
Anyway,
time.
I don't see,
That's why I'm
let me
filing the
see,
reports.
এই রিটেন নোটস গুলো কি ফাইল হয়েছে? এটা কি ডিফেন্ডেন্ট,
Judgment letter.
I am for the decree holder.
ডিগ্রি হোল্ডার,
Madam-
প্লেন্টিফ?
Yes. My notes have already been filed.
আচ্ছা, এই দেখুন তো এই রিটেন নোটস তো এরা ফাইল করতে বলেছে, এটা ফাইল হয়ে গেছে, তাহলে এটা হিয়ারিং কনক্লুড করে দেওয়া হচ্ছে।
না, না, ওটা আমার।
না, এটা ওনাদের।
তো ডিফেন্ডেন্ট প্লেন্টিফ পিটিশনারের রিটেন নোটস
আমরা
আমার
ফাইল করে
চেম্বারে
দিয়েছি।
যেটা আছে শুধু দেখছি ওই অ্যাপ্লিকেশন রয়েছে, কোনো রিটেন নোটস দেখছি না।
Just give them a copy. Spare copy আছে? Just tear the maximum. Yes. But we have highlighted the admission that they have made in the affidavit in opposition filed to my
Your
executive.
রিটেন নোটস,
Yes.
ওকে।
Malad, in the tabular statement, my total claim is 10.52 crores. But Malad, there is an admission by the judgment debtor that at least I am entitled to 4.37 crores.
Anyway, that is that, you see, I have,
Arguments are complete.
yes, I have made that clear. You see, judgment debtor may say many things, okay. They may say only 1 rupee is due. But the court, the executing court is bound by the decree.
Yes.
The court cannot go beyond the decree. I've clarified this point. Yes, hearing, yes, record and order. Learned advocates for the parties file written notes of arguments. Let it be kept with the record. Hearing is concluded. CAB.
Grateful.
আচ্ছা শুনুন, এইটে এটা তো আজকে
সঙ্গে কে ছিল? হচ্ছে বন্ধু ছিল।
অসুস্থ ছিল।
My lord, I'm for the plaintiff.
But I appear on behalf of the defendant number 4A and
My
4.
lord,
today which application is
my lord,
submitted?
pursuant to lordship direction, last direction, my lord,
Yes.
I have taken the steps for filing the application for substitution.
Yes.
My lord, I have served all the parties. My lord,
Yes.
today also I have served the copy of this application.
So just you have served today, they cannot
My lord,
submit.
my lord, very well. They know that the persons dies. My lord, I have no. There is no such pleading there.
After how many days you have filed
My
this
lord, it
application?
is a partition suit.
No. After how many days you have filed this application for
My
substitution?
lord, on Friday, my lord, on Thursday,
And
my
how
lord.
many days after the date of death?
Date of death, my lord. This is my lord. My lord.
Lord, I don't think there should be any difficulty in accepting the
My lord.
substitution.
Yes, yes. My lord, he died on, my lord, 15th, 4th, 2 months.
Okay.
My lord, it's a partition suit. My lord, the question of the,
So which defendant died?
my lord, the original plaintiff number 3.
Okay, plaintiff number?
3. And also, my lord, the defendant number, my lord, huh?
পরীক্ষিত মারা আছে।
Parikshit Burua.
আমি দিচ্ছি আপনাকে।
Yes. 1B3.
1B3.
1B3. Roman 3.
Okay, which paragraph of your petition?
This is
Grounds, which paragraph?
this is stated in paragraph, my lord. 8. My lord, kindly come to the paragraph 8, my lord.
Underline করুন।
My lord, this is, my lord, I have stated in
Okay, so this is with regard to
8, 9, 10, my lord.
8. 9 is 1B.
2 persons died, my lord.
In the meantime.
Yes.
অনেকদিন মারা গেছে। পরীক্ষিত অনেকদিন আগে। পরীক্ষিত অনেকদিন আগে। পরীক্ষিত অনেকদিন আগে মারা গেছে।
My lord, if you look,
Okay, Annexure
come to
B,
page 12, my lord.
page 12.
Yes.
Yes.
11 থেকে page 11 থেকে
My lord, that the substitutions was prayed for, my lord.
Prosun Borua.
From paragraph 11.
Prosun Borua, plaintiff number 3, died on 15th April 2025.
My lord.
Okay.
My lord.
And
Another person
defendant
died.
number 1B3, Parikshit Borua, died on 9th October 2024.
24, my lord.
Okay, these are the
These are
two
the-
deaths in the meantime.
Date, my lord, and their substitution, the names of the heirs also pleaded in the my application, my lord.
পরীক্ষিতটা তো পেলাম।
And the amended copy, annexure D, my lord. It starts from, my lord. Yes. It starts
page 21.
page 21, my lord. Page 21, my lord.
Yes.
Page 21, that is Prosun Kumar Borua, to be substituted by his wife, Korobi Borua, and son, Rohit Borua.
And this
And my lord.
Prosun Borua.
22, yes. 22, Parikshit Borua, substituted by Priyanka Borua and Prithviraj Borua.
No, this Prosun Kumar Borua is Korobi Borua and Rohit Borua.
My lord.
And the other department is Parikshit Borua.
Parikshit Borua,
I-
to be substituted by his wife and son,
That is Priyanka Borua and
Prithviraj Borua.
Prithviraj Borua.
Yes, my lord. And
Yes.
And my lord, and genealogical table, kindly come to page, my lord, at 29, my lord.
page 29.
Yes,
Genealogical, I have indicated in green ink, my lord. That is middle of that Prosun, date, Kaveri and Rohit Borua. Underline in green ink, my lord.
yes. Prosun is Korobi Borua and Rohit Borua. And so far Parikshit Borua is concerned, Priyanka Borua
yes,
and Prithviraj Borua.
my lord, I am to oblige, my lord. Please.
Learned advocates for the parties are present. The petition, the applicant has taken out an application for recording the death of plaintiff number 3, namely Prosun Kumar Borua, and death of defendant number 1 within bracket B within bracket 1(3), Parikshit Borua. It is the contention of the applicant that Prosun Kumar Borua,
1B3, my lord.
defendant number 1B3.
Yes.
Yes, it is the contention of the applicants that Prosun Kumar Borua, the plaintiff number 3, died on 15th April 2025. Stop. Leaving behind the applicants Korobi Borua and Rohit Borua as legal representatives. Stop. It is further contended that the defendant number 1B within bracket 3, Parikshit Borua, died on 9th October 2024, leaving behind Priyanka Borua and Prithviraj Borua. Stop. It is also contended that the name of the deceased plaintiff number 3 and defendant 1B3 be deleted, and the name of the applicants being legal representative of Prosun Borua and name of Priyanka Borua and Prithviraj Borua be substituted in place and stead of Parikshit Borua. Upon hearing the learned advocates and considering the facts, this court is of the view that delay in making this application should be condoned, and the names of the deceased plaintiff number 3 and deceased defendant number 1B3 should be substituted in their place and stead. Let there be an order in terms of prior A, B, C, and D of the master summons dated 26th day of June 2025. Let this suit appear.
My lord, necessary amendments may be carried out in your lordship.
Yes. So shall I directly mention liberty is granted to the part?
my lord,
Let this,
My lord, there is one more. My lord, there is.
let this suit appear on.
My lord, if I may just indicate one thing before your lordship just concludes.
Yes.
My lord, on the last occasion, on 16th of June, if your lordship comes to the order, Mr. Learned Advocate Mr. Pal Chaudhary has carried out his part. That is paragraph 4 of the order. If your lordship could just take the order of 16th of June, last order. Yes.
Give the order.
16th of June order take to them.
16th of June.
কপি নেই বোধহয় আমার কপি নেই আবার ফাইল এসে পৌঁছেছে না ঠিক আছে জাজের ফাইল জাজকে দেওয়ার জন্য বলছি In substitution application, there was a direction for filing of the substitution application at the instance of the plaintiffs. Now, that has been carried out. But there was also another direction on me. That is for the defendant number 4A and 4B. Your lordship,
that is order dated
16th of June.
16th of June.
Paragraph 4. And this is being complied with. Yes. And if your lordship comes to paragraph 7.
Yes.
7 years.
Because if your lordship correctly remembers, my lord, on the last occasion, Learned Advocate Mr. Pal Chaudhary appeared on behalf of the plaintiffs after a very long time.
Now, which
Now- yes.
are you to move any application?
Yes, we were directed. We were directed. Sir. We were directed to provide with copies of the 4 GA applications that are pending before your lordship
Your
today.
applications are
Yes,
this-
those are all at my instances.
I've got.
And we have served pursuant to your lordship's order of 16th of June. On 18th, we have served. But there is a situation. 2 of these applications are directed against the plaintiff. That is GA 21 and 23. I was wanting, my lord, if your lordship could pass a direction for affidavits, because Mr. Palchodhuri's stand in this particular application is very, very badly required. I do not know whether
No, question is, let these amendments be carried out, okay?
Yes,
Thereafter.
it may be carried out.
Thereafter, these applications will come.
But pleadings may be complete in the meantime. Otherwise, there will be unnecessary delay, my lord. If Mr. Palchodhuri wants to exercise,
No, let
This
it be,
option.
let it be completed, or you can mention it after completion.
I will.
My lord,
Okay.
may I make one submission? Time and again, my lord, all these 4 pending applications that are before your lordship today are his applications.
Yes.
I said this on the last occasion also. There is a very contrary stand being taken by my learned friend's client. On the one side, she goes around telling everybody that 993 is pending. Please stay your hand, don't do anything. Back off. On the other side, she takes no steps to have 993 heard out. None whatsoever. Time and again, the 4
Anyway, before hearing anything, any applications of the suit, these amendments are to be carried out.
No, I'm not on that, my lord. What is happening? This is an application which has come now. These applications have been filed in the middle of last year. He's not moved the application.
Anyway,
My lord,
it will now be
my-
taken up.
So far that the applications for the transposition, they have filed 2 applications by 2 his clients, madam. Now, 2 applications are now infractuous.
They are redundant.
This is the
You're-
problem.
Redundant.
You have
This
filed
is the
your
problem.
opposition to
No.
this?
My lord, I have not got any opportunity.
But this
to file
submission cannot be
opposition,
accepted.
But no.
An endeavor is being made.
I
An
can
endeavor
make
is being
one-
made to frustrate
I
the
can
applications.
make my oral objection to this.
You file, after these amendments are carried out, you file your opposition, let it be taken up on a
Mr.
particular date.
Palchodhuri's clients have sprung out
Post
for
doc-
2 years, my lord.
You
to
take
plead.
steps, I think you take steps to carry out this.
My lord, then my lord, liberty be given to file my opposition.
Absolutely. That is what I want.
My lord, may I make
Let
a
the pleadings be
submission?
complete.
May I make a
Pleadings
submission?
are
here?
incomplete at this point of time.
No, pleadings are complete.
Mr. Palchodhuri is making a submission.
After bringing the years on the record,
Yes.
they have to engage you again. I think you have
My
to,
lord, yes,
you have to
yes.
accept Vokalatnama.
My lord, I was there all along.
And Mr.
Anyway,
And in the meantime, my lord,
see, I am fixing a date for further orders. Okay,
yes.
on that day, if all the affidavits are complete, I shall
I will
fix a
come.
date.
But if there may be a
Let-
direction,
Let this,
well, let there be a direction.
after taking the necessary steps, let this matter appear on 2nd August 2025.
I'm sorry.
It's a Saturday working date.
Yes,
Okay.
yes.
Second step.
My lord, may I make a submission? Let them now press these 4 applications.
Yes,
It's about
we are
time
willing
they
to.
do it.
We are
They're
ready.
not willing to.
We are
He
absolutely
may
willing
say
to.
what he wants.
But Mr. Palchodhuri
See, what is
coming
happening
in the
today-
coming in the
what
middle
is
of this,
happening
my lord,
today,
has
my lord,
circumstances.
he's taking
My
an offense.
objections is in writing, it is not necessary.
Not necessary. He
My
can
lord,
make it
Mr.
always
Palchodhuri-
happen.
Okay, on that day, if you are not willing, I shall take up those applications.
Yes. Well, there should be a
My lord,
categorical submission.
My lord, instead of second, my lord, kindly fix it on 4th, my lord.
Let it be
Okay.
on second. The case will be less. That's a working date.
My lord, may-
Cases will be less. It will
My
be
lord,
easy. It will
Second,
be
he's
easy for
saying,
the court.
second, he's saying because of Shoni.
No problem.
Second,
My lord, may-
Yes.
some other,
kindly
Yes.
Fix it on 2nd.
Why?
Today, my lord is fixing on 2nd, but ultimately that they will not be.
that will not be a
That-
workable
that-
day.
that-
Why not? If you come, it will be a working date.
It may be
My lord-
shifted to September
my lord,
also.
that is
Right.
That is your tradition,
Sure.
lordship.
Kindly keep it on Monday. my lord.
On Monday.
One
and
more
4th.
thing, lordship.
Okay, let it be 4
Fourth
or
of-
5/4/2025.
5/8.
5/8
May I
2025.
respectfully statement one more
And
thing, lordship.
opposition,
My lord,
if any,
we are
intermediate,
the, my lord, we are
if
the,
any.
we are the joint learned special commissioner, lordship, appointed by the court, lordship. We have acted, we have discharged our duty.
No, they have not yet.
We have-
No, we've done.
My lord, my
How-
lord, we have-
how dare he
we have
say
a
not?
Lordship,
His report
lord,
is filed, he's
no,
saying not
the
done.
last
How can you say that?
my lord, we were hesitating to submit before.
But the report, once the report is accepted by the court, my lord, they are
paid, but after that, we started.
No, last occasion, there was a direction to pay
Yes,
the
lordship.
May Lord, I'll
remuneration.
come to
What
that.
about that?
I'll come to that, my lord.
from the respective shares.
Directed to
My
pay
lord,
all.
No, can't be, my lord.
No,
Can't be.
What about that, you see?
300 James, my lord.
No. Receiver cannot. Receiver
There
is
is a
private
direction
funds.
to be shared by the party.
My lord,
Yes, as per the
come to
direction.
that.
parties, very.
No, no, but why it is not done?
Cannot be modified.
30 parties, 30 parties.
There are-
my lord.
Maybe.
I am
How much
appearing
have you-
for 5 plaintiffs.
So have you instructed your client to do the
Look,
needful?
700 rupees per head will have to be paid from 25 people.
My clients are willing. Absolutely, they are willing.
300 GMs means how much? You say
5,100.
5,100 only.
5,100
We are willing
divided
to
by
make the
40.
payment today also.
Got that to collect because the 330 people are there, my lord.
But that
He
is the
taking
way it is to be
benefit of
done.
everything.
But that is the way it is to be done.
So have you paid your
Yes,
part?
we are carrying it, man. We will do it today. In course of this day, we will do it.
Val Chaudhary, you also ask your clients,
My lord,
please.
I will ask.
We are
That will
absolutely
not be
willing.
done.
But we
My
want
lord, this
impression is
submission
given to
coming
the-
from my learned friend that we have not completed our work, the report is on
unless,
record.
unless the report is being accepted and they are
No, 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 no.
discharged of
They are,
their duties, my lord.
Work is
they are
completed.
discharging
They are
their
not-
functions. Okay.
That's right.
But the problem is
Acceptance, non-acceptance, that's a
It's
different
got
issue.
nothing to do
that's
with
a different thing, man. Unless the report is taken into record.
it. It's on record. It's taken on record.
Submit one more thing, Lordship. On 16th of June, Lordship, my landed senior friend started appearing on behalf of the plaintiff, Lordship. On that day, he filed one affidavit for declaration.
I will deal with it, my lord. I will deal with that affidavit that he has.
I will also deal with that affidavit.
He has filed one affidavit for declaration.
Yes.
Kindly see the contents of the affidavit of declaration. Kindly
It
see,
can't be
Lordship.
done that way.
It's absolutely ineffective and inoperative in law.
Kindly take up that affidavit declaration.
I shall take it up on
Your
the next day.
2 lines
Let
from the
these things-
affidavit will do, man.
Very
Let these
true.
things be done, okay, in
See
the
the
meantime.
contrary, just 1 minute.
Paragraph 6.
See the contrary stand being
Lord,
taken by my
Lord,
learned friend.
Categorically stated by my learned senior friend appearing for the plaintiff, it is further paid that honorable court to decide the instant suit as
Has
withdrawn
withdrawn.
without
How?
any further adjournment as the plaintiff's deponent Sri Rajat, the deponent.
Because I have
Sri Rajat
submitted
Kumar
because
Burua can't be.
everything is complete, my lord.
Absolutely. Can't be.
Unnecessarily it is being hand up.
My lord,
Unnecessarily it is being hand up.
my
My
lord
lord,
are no more willing to contest the
How?
instant suit
How can he say
as
that?
issues resolved.
Well, they are giving a declaration of this kind
Mentioned by
and they are calling that the transposition applications are
I shall also deal with that. on the next
absolutely.
day.
We will deal with it.
My lord,
It's a
see,
very serious state of affairs.
see the contrary stand being taken by my learned friend.
After 65 years, suddenly he
far
comes
as-
to he comes in the way to say that the matter is over.
He
Okay, my
said,
lord.
just
my
one,
lord,
he
in the
said,
meantime, my lord, I will file my opposition to the. My
he,
lord,
my lord, he
And
said,
I may be given the liberty to
No,
come up
but
with
in
my
the
reply.
meantime, please, both of you see that the.
I will come up with a reply, man.
my lord, what my learned friend is saying, that our report is not, has to be accepted. He has acted on an earlier report.
You see, the remuneration
How?
does not depend on acceptance of the
Correct.
report.
Exactly.
Oh, this is not an
We are
ambiguous
willing.
stand.
We are willing to pay, my lord. Let the other co-sharers have
He
their.
acts,
Yes, Mr. Pal Chaudhary, please
Let
take
them make
that.
communications with
My
their
lord,
clients.
he acts
I
on
will
an
take care of.
earlier report that is on record. His client has
We
acted
will
on
deal
it.
with it at the relevant point of time.
He's acted on it.
কত
will
দিতে
deal
But
হবে
when it
বলে
comes to
দিও।
my report, he raises a red flag. Why?
We have complied so far as your lordship's direction, man. We have complied it. for the
Okay,
time.
come on the next day.
My lord, may I, subject to your lordship's leave, my lord, to ease the pressure, my lord,
Yes.
may I hand over a short list of dates, my lord? That's all I'm.
Submit it on the next day.
Next
I
day.
shall
Very
hear the
আমাকে
matters.
একটু দিয়ে দিন একটা copy।
Very well.
My lord,
আমার একটা copy দিয়ে দিন না আগে।
হ্যাঁ?
একটা copy দিয়ে দিন।
File করি না।
আমার দিন না, আমার পড়তে
No,
না,
no,
না,
file
আজকে
করি।
শুধু জিএটা ডিসপোজ হয়ে গেল তো। হ্যাঁ, আজকে জিএ 25টা ডিসপোজড হলো। হ্যাঁ, হ্যাঁ, হ্যাঁ।
my lord, 5th August, my lord, in the meantime, opposition, if any, will be filed.
Yes,
My lord,
yes.
and let them not take any other plea that this hearing cannot take place. Let them argue the matter now. We are willing to hear out the matter and put an end to this.
Yes, yes.
That is
1960 suit.
1960s to unnecessarily, if your lordship goes through the record,
45
all
years-
applications have been filed by him.
Let me make one thing very clear. No endeavor is being made for the last 65 years to complete this suit. The report of the Artsville Commissioner is still not being accepted.
But
We
he's
had to,
acted on it.
but we had to know.
He's
We
acted
had
on
to
it.
we had to take out.
Acted on it.
But
Every-
we had to
everybody
take out a fresh application. My learned friends were appointed.
Now let us do the needful.
Yes.
Everybody is
But
acted
they
on
are
it.
only unnecessarily agitating these issues. This can be resolved at the
Okay,
point of
okay.
hearing.
Come on the next
My
day.
lord, his ancestors also acted on it.
Everybody
He's
has
the
acted on it. Everybody has sold off their shares. Today he is making a noise about it.
My lord, the preliminary order passed by this court lordship, that is unchallenged lordship. The report of the partition commissioner filed by the Artsville commissioner.
Hey,
that
আমার
is still unchallenged.
Let us see what we can do on the next day.
The next matter,
Yes.
I have a chapter 13A, which is not there in the list. My learned
Item
friend have an
20
application
item
to take
21.
21
yes,
years.
take on record, my lord, the written statement affidavits are complete.
My lord, I am filing the affidavit in reply to the main, to
My
the
lord,
application.
I have a chapter 13 and let it appear with that, my lord. The next week, lordship, any date keeps it, my lord, I'll be there to address. এইটা আসে যেন চ্যাপ্টার 13 এটা
Now,
আসেনি
Okay, item 21.
yes
Let this matter, GA5 of 2025, appear along with
GA number 2 I have given the number to my lord's court officer
GA dash of 2025 on
GA 12 GA 12
two ছিল।
on
GA 2 of
14/7 on
2012
14/7/2025.
14/7/2020
14/7 কিন্তু তোর Monday হচ্ছে।
To appear as adjourned motion.
Lordship, both should appear as a chamber application.
chamber application
Both
for
chapter
final
13
disposal.
for final disposal. Okay.
Let
GA
it
2 of
appear as adjourned
2012
motion. You have filed your affidavit in reply.
Lordship,
affidavits are
Please, a
one
copy
is the
as well.
extension one is the chapter 13
Okay, let the affidavit in reply filed in GA5 of 2025 be kept with the record.
Lordship.
The other affidavits with regard to the other
That is
applications are
complete. That is
complete.
completed long.
Okay, it will appear on 14/7.
grateful
But would your lordship continue after lunch?
Yes.
My only one little
Yes.
submission, my lord, only one thing just indicate the next matter. I am for the judgment debtor. Then application has been taken out by Mr. Lakmani's client for attachment of the for decretal amount to be paid for
Item 21.
24.
My lord, I have
My lord,
some submissions to make. Your
Only,
lordship,
only I just
taking it
pointed
up at
out
2 o'clock.
this is a
So come at 2 p.m.
it should have been in a chamber.
Lordship, I
The
appear on behalf of
execution
the degree
application
holder.
where an application
As because it is already appearing, I don't want to
As your
shift
lordship.
it.
No, no, does lordship kindly takes it up after recess, your lordship. Everyone has to make some submissions. Yes,
I don't have any submissions.
That is GA1 of 2025.
GA1.
Yes. I don't have any submissions to make. It's a fight between Mr. Lakmani's client and
Mr.
Okay, I shall consider.
Great, lordship. I appear on behalf of the decree holder. I appear on behalf of the state. But I am the applicant in GA1. Lordship, your Lordship's last order, Lordship, there was a direction, peremptory direction on the applicant of GA1 to file its reply. They have not done so. Lordship will see your Lordship's order dated 12th of June 2025.
But I have already indicated that I will not use an affidavit to GA1. I am for the judgment.
Lordship, the GA1 is between the intervener and the decree holder per se.
Use an affidavit. I have indicated that.
My lord, I appear for the state, my lord, and I'm seeking for your lordship's leave, my lord, to intervene in these proceedings, my lord. My lord, I represent the Directorate of Economic Offence, and I'll indicate your lordship's, my lord, why I've been,
Have
my lord,
you taken out any application with regard to
my lord,
that?
not, my lord,
Oh, your
not, my lord,
lordship.
I do not even have a copy of the
Lordship, even on
execution
the
petition,
last
my lord.
occasion, my learned friend had appeared.
No, I did not appear, my lord. I am appearing
Someone
for
on
the
behalf
first
of the
time, my lord.
state, someone on behalf of the state had appeared. I stand corrected. But
I'll just
they
indicate,
also
my
take
lord.
this leave on the last occasion to file an application, but no application has come forward.
Now, we need a copy of the execution petition, my lord. I'll
We can
just
always-
indicate, my lord. My lord, so far as the decree holder is considered, my lord, we have credible information and our investigation reveals that there are, my lord, umpteen numbers of FIRs which has been registered.
Yes.
My lord, in respect of, my lord, a cheat fund, my lord, operated by the decree holder. My lord, from various depositors, the amount runs more than 100 crores. And we have, my lord, credible, my lord, resources with us, my lord, which shows that this money has been, my lord, thereafter being routed. So we really do not know, my lord, what amount.
What was the suit for?
Lordship, suit for recovery of money lent
Against,
and
You
advanced.
see,
against money lent
now
and
the
advance.
question is, you see, executing court cannot go beyond the decree.
Grateful,
The
Lordship.
decree has already been passed. Executing court cannot go beyond the decree.
Lord,
So what is your role in the so far the suit is
Lord,
concerned?
my role is, my lord, so far as the money recovery is concerned, my lord, we will have a right, my lord, to, my lord,
That's a
ask for an
different issue.
attachment.
That's a
My lord,
different
attachment
issue.
of this money, my lord,
But
which should go in the interest of the
no order
depositor.
can be passed in this execution case. If you have a specific right under any law, you can proceed against them. That does not affect this suit.
My lord,
So far, this suit is concerned, you see, the execution case is concerned, executing court cannot go beyond the decree because if this decree is varied in appeal or revision, whatever it is, then it is binding upon the executing court. Now the executing court is bound to execute the decree. If there is no order of stay or if there is no application to declare this decree as a null and void, so far your case is concerned.
But I'll just indicate, my lord, to just answer to your lordship's query, my lord.
No, what is your role so far the
My
execution
lord, the
case?
recovery of the money is important. My lord, your lordships will, my lord, appreciate, my lord, that I am playing, my lord, a pivotal role in investigation. My lord, this money, we do not really know under what circumstances it was, my lord, disbursed to the judgment debtor. What was the terms of the loan facility? Who has repaid back? And these are all matters of investigation, my lord. My lord, I have a pivotal role today, my lord, to at least
who's
know.
in GA1.
I am
Lordship,
the
this is
applicant.
the intervener.
So you have annexed a copy of this bail order.
Yes, my lord, may I just, my lord, indicate in brief what the matter is? Very brief, my lord. The plaintiff in the suit runs a Ponzi scam. He defrauds, my lord, citizens to the extent of hundreds of crores. And I, my lord, am one of the parties who suffered 41 crores in this Ponzi scam. So, my lord, several persons lodge police complaints against this individual, my lord, which culminate into FIRs. After, my lord, the FIRs were investigated, my lord, charge sheets were filed. Now, the plaintiff, my lord, in these charge sheets, my lord, has been charged under Section 3 of the West Bengal Protection of Interest of Depositors in Financial Establishments Act 2013, which is a special statute. Now, my lord, the plaintiff spends, my lord, nearly 3 years in jail. His wife, my lord, also spent several years in custody and, my lord, died in custody. Finally, my lord, the plaintiff was granted bail by this honorable court because, my lord, the investigation was concluded. But, my lord, under this act, if a lordship may just, my lord, consider this act for a moment, my lord, under this act, when a party is charged under Section 3 of this act, my lord, the state comes into play. And the state, my lord, is duty bound then to, my lord, attach the assets, my lord, of the person who has, my lord, played fraud. Not only that, my lord, the state is duty bound to, my lord, reach the money, trace the money. And, my lord, under this act, Section 5, I will show your lordship, the state is also duty bound, my lord,
to attach the properties.
You are representing?
I'm the intervener. I'm the victim, my lord, of the, my lord, Ponzi scam.
What was the decree passed in this case?
My lord, may I just, I will indicate your lordship.
See the
My lord, under my lord, this act, my lord, the 2013
Only
depositors.
thing is this affidavit in opposition is passed by the decree holder. You have filed your reply also.
No, my lord, reply your
So
lordship.
whatever you state, you file your reply. Okay.
But
And
kindly
give a copy to the
My lord,
state
may I
authority.
also pray, my lord, kindly, my lord, issue notice upon the state. My lord, they have
Serve them a
volunteered.
copy, then only the question of notice.
Very well, my lord, let there be a direction, my lord, I'll give a copy.
Your Lordship, I object to this. This is coming from an intervener to the execution application who has not even been impleaded as a party, and he's asking the state to become direction
Right,
on the
but
state.
we will not be a party, my lord.
Like,
This cannot be
Lordship,
disputed. How will I be a party, my lord? I am an investigating authority.
Like my learned friend has filed an
But this is
intervening
the
application
exact,
with
my lord, the
with
modus
short term-
operandi, my lord,
Your
what
Lordship,
has been done by the decree
kindly
holder.
takes your Lordship's order dated 12th of June. Your Lordship, the state was represented. They made the exact same prayer. Your Lordship, kindly takes 12th of June.
Advocates for the applicant
They
in
do not
TA 1 of 2025 is present. Learned advocate for the decree holder and learned advocate for the judgment debtors are also present. As affidavit in reply is to be filed by the applicant intervener, let affidavit in reply be filed by 11.
Lordship, the last direction was peremptory. Lordship, kindly takes your last line of 12th of June. Lordship, this is not the first time that they are asking
May I
for
also file an affidavit, my lord?
If your lordship wants to hear me today, my lord, I can argue today. Your lordship will only record that nothing stated in the, my lord, opposition is admitted by me. That's all. I don't need to bring on record.
No,
I'm ready to press the matter.
Okay.
So let him press
Get one more opportunity to file affidavit in reply by 11/7/2025. By reply by 11/7/2025. Let this matter appear on 15/7/2025. Learned advocate for State of West Bengal.
My lord, Directorate of Economic Offence, my lord.
Learned advocate for Directorate of Economic Offence intends to be added as a party in this case. However, necessary applications be made.
Grateful, Lordship.
Very well, my lord. I'll immediately file an application.
The same prayer was made on the last occasion as well, Your Lordship.
But that does not take away my right, my lord.
Anyway, make
I will
necessary
immediately file an application.
Question of right, my lord, he's duty bound to, my lord, do what he's doing. It's a duty is discharging. There's no question
So
of
let
right.
my learned friend come up with an application, I'll deal with it accordingly. Grateful, Lordship.
Grateful.
Item 50. Got a 2 PM fixed. 50 to witness action.
80 holo.
50. 15th. 2 PM fixed matter, yes.
Lordship, may I pray for one indulgence since my learned Lordship, except apart from 15 July, could it be 14th or 16th? Lordship, I'm some personal difficulty on 14th. 17th if it
16th.
If it commences to your Lordship, can it be 17th?
ঠিক আছে 17th করে দিন
Grateful, Lordship.
Item number 56,
Lord, I am for the defendant.
My lord, I'm appearing for the petition, Your Lordship. Your Lordship, there was a direction to file an application for transfer of the matter from this court to the commercial division.
What is that application?
Your Lordship, it was not filed due to some personal occupancy of the client, Your Lordship. It will be filed by tomorrow, Your Lordship.
Yes, record an order on the prayer of the learned advocates. The matter stands adjourned till 3/7/2025.
Your Lordship, a bit longer. Please, the court.
Okay, 14/7/2025.
My lord, may I just pray for one indulgence? It's appearing in the list as witness action. My lord, their application will be taken on record and allowed, and thereafter the transmission has to happen from regular to commercial.
That application will be taken
Yes,
up.
my lord. So if it is,
Even if it is appearing under the witness action, it can be taken up or it can be listed under the heading new motion.
that is what I was suggesting.
No, unless he files that application,
Yes,
it
yes,
cannot be listed.
Deeply.
Your Lordship, for the petitioner, last two occasions, my Lordship, if you remember, we had served the notice on the opposite party, but they had never appeared. We tried reaching out to the council also, but the council verbally had mentioned that they are not briefed on the matter any further. It fell from the Lordship that we should take the necessary actions. We have filed the GA application for the publication.
Let us see the GA application.
Well, Lordship, it was deferred for a few days since the client could get it signed. He's on personal.
GA application is yet to be filed.
Yes, Your Lordship. It will be
Okay.
filed today. If there is any other direction, Your Lordship.
Okay, on the prayer of the learned advocates, you file it and you mention that application. On the prayer of the learned advocates, the matter stands adjourned for this week.
Shall it be kept on 7th, my Lord?
Next week, that 7th, there is some uncertainty. I'm just adjourning it for this week. After you file that application, you mention. After you file it, if you file it this week, you mention.
Your Lordship.
Huh? Let this matter, it's better, let this matter appear on 14/7.
Obliged, Your Lordship.
Item number 26.
Your Lordship, kindly keep this matter on day after tomorrow.
Okay, not today and tomorrow. No, let it appear on 3rd. Okay.
Okay.
Let this matter appear on 3rd July 2025.
Item number 27.
দেখি অর্ডারটা কি হয়েছে লাস্ট Yes, record an order. None appears for the parties, although today is fixed as a last chance. Let administrative notice be issued upon the parties and their learned advocates. Let this matter appear on 5/8/2025 for report. না অ্যাডমিনিস্ট্রেটিভ নোটিস করে দিয়েছি হ্যাঁ হুম না learned advocate for state না learned advocate for economy না learned advocate for state আছে কি দেওয়া তাহলে দুটোই করে দিন অ্যাপিয়ারেন্সে কি দিয়েছে ডিরেক্টরেটে লার্নেড অ্যাডভোকেট যে স্টেট অফ ওয়েস্ট বেঙ্গল মানে এইদিকে যে যে সাবমিশন করছিল তার ইয়েটাই দিয়েছে আচ্ছা ঠিক আছে টেক নেসেসারি অ্যাপ্লিকেশন
Item number 28.
Item number 20, I am the petitioner, Your Lordship. Lordship has directed.
You're for the plaintiff?
Plaintiff, Your Lordship.
Yes.
Earlier occasion, Your Lordship had directed to file the vocalat number. We have done so, Your Lordship. We are supposed to file order on Rule 10 application, but from instruction from our client that has been already filed earlier, Your Lordship.
Let me see the order, last order.
Yes, Lordship.
on the last occasion, you were granted liberty to file vokalatnama as well as to inspect the records.
We have inspected the record, but we have not found that the substitution already taken place. That has not been taken, but from instruction that order on Rule 10 was earlier filed and substitution had taken place, where we have to go through the old record, you say the GA. So kindly grant us some time to go through the old record.
Yes.
না সব dispose of হয়ে গেছে বলছে।
Learned advocates, yes. For the plaintiff is present, you cause inspection and see in what position the suit
Yes,
is
Your Lordship. Yes,
at present.
Amendment has been carried out, but now order on Rule 10 needs to be filed because HON'BLE also died, Your Lordship. But under instruction, we have been informed that that already been carried out, Your Lordship.
Yes, you cause inspection to the records. Learned advocate for the plaintiffs plaintiffs is present and prays for time to take necessary steps. The matter stands adjourned till. Okay, I'm keeping it on 22nd of July,
Oh, Your Lordship.
22/7/2025.
Obliged, Your Lordship.
Item number 29.
Lordship, in this matter, I appear on behalf of the plaintiff. On the last occasion, Your Lordship had given a last chance to the defendant, my lord, to take inspection and discovery of my documents, my lord. That has not been done. If I may, can I kindly pass over a short compilation of 3 orders to Your Lordship in this matter? First order, my lord, is an order of 6th February 2025 by a coordinate bench. Lordship kindly reads, affidavit of documents filed by the plaintiff is taken on record. My affidavit of documents on record, 6th February. The second paragraph, Lordship, learned advocate for the defendant submits that there is a possibility of settlement. Thereafter, Lordship kindly comes to the next order, which is passed by Your Lordship.
This is 6th February.
This is 6th February 25.
Then 21st April.
Then 21st April. In the meantime, the determination changes, comes to Your Lordship. Lordship takes up the matter, first order.
21st April also.
Yes, my lord.
The matter was adjourned.
Adjourned because the defendant did not come and an
an
opportunity was given.
Was granted to carry out inspection by 6th May 2025.
Yes. Thereafter, Lordship finally takes the last order, my lord, 11 June 2025.
Yes. June. Yes, this is 11 June.
Yes, my lord.
So they are
Lordship, 5 months ago, the defendant comes up with a proposal that he wants to settle. Thereafter, he does not appear before Your Lordship anymore. Neither is he responding to any of my letters or anything. So, Lordship, I'm kindly praying that is right.
So, in the meantime, no inspection was taken.
Nothing, my lord.
Yes.
My lord, I appear for the defendant, my lord.
Yes.
My lord, this matter, I think, is pending for discovery and inspection.
No, but you are granted the last chance to take necessary inspection on or before 26 June.
My lord, I apologize for not taking it, but my lord, my client is more than 90 years old, and I'm not being able to contact him for unknown reasons, my lord. Kindly grants me a fortnight's time. I will try to establish contact. If not, my lord passes necessary orders.
Lordship will kindly record that I object to this, my lord.
Learned advocate for the plaintiff and learned advocate for the defendant are present. Today was fixed for necessary orders and defendant was granted last opportunity to take inspection and defendant was granted last opportunity to take inspection on or before 26 June 2025. Today also learned advocate prays for time to take the necessary inspection of the documents which is objected to by the learned advocate for the plaintiff. However, this case stands adjourned till 14/7/2025. Let the matter appear under the heading to be mentioned. The defendant is granted liberty to take inspection in the meantime.
Lordship will kindly record that this is peremptory.
Telling which necessary orders will be passed.
Grateful.
Grateful, Lordship.
Lordship, I have already taken inspection of the records.
You are
Lordship,
representing the plaintiff.
I'm for the court liquidator, Lordship.
You are for?
I'm for the liquidator, Lordship.
Yes, yes, yes.
Lordship, what happened was this. Once I've checked the records, I find that there have been two decrees in this matter. One, a preliminary decree, and then a final decree. Now, Lordship, what has happened is this, that the decretal parcels of land, a great part of these parcels of land, have been wasted by the land reforms officer. So we wrote to the BLRO. The BLRO wrote back to us, giving us the details about the land that has already been wasted in the West Bengal government. Now, Lordship, we intend to take out an application, but it could not be affirmed because though we gave a translated copy, the department insists that it has to be an officially translated copy. And we have already given a letter to the official translator who has said that they will need at least 4 weeks' time to prepare this translation. So, Lordship, kindly gives us 4 weeks' time so that we can prefer an application. Let the land be divested.
And compilation of the documents.
Lordship.
And list of dates and whatever.
Lordship, I will do whatever is possible to assist this court, Lordship.
Yes. Mr. Bashu, learned advocate for the petitioner, liquidator, is present. Mr. Bashu prays for time to collect the relevant documents to file a compilation as well as a necessary application in this regard for further orders. In the facts and circumstances, the case stands adjourned till 2nd August 2025 for taking necessary steps and filing necessary application. 2nd August is a working Saturday. Okay.
Working Saturday.
Yes, yes, yes.
So it's also penalty.
So anyway, let us utilize it.
Lordship.
Yes.
Lordship may recall, this is the that matter whereby the subsequent order passed by your Lordship. Initially, it was the pleasure of your Lordships that the whatever the proposal coming up for the purchase of the same, that has to be forwarded before the receiver. Receiver would held a meeting, and accordingly that has to be submitted before your Lordship.
Let me see the last order.
Yes,
my lord.
Okay, orderটা কত ছিল জানো?
13-6.
Now,
Also
supposed to file your necessary suggestions.
Yes.
Today.
Intending purchaser and the
all the parties.
Yes, all the
Yes.
I appear for the plaintiffs. I am filing.
One other thing is this, you see, one of the co-sharers, that is the defendant, okay, who is appearing in person, intends.
11, here.
Yes, defendant number 11 intends to purchase. Are the co-sharers ready and willing?
He is giving much lesser value.
No, question is very well. I accept that.
But everybody is willing to.
It is no. He is giving lesser value, but the question is, it will not go to any third party. That is the thing.
That is his contention.
No, you see, if you give it to your co-sharer, it will not go to third party. It will be within your heirs and family. So if you are agreeable, you can suggest. Otherwise, I shall consider your suggestion and pass necessary orders.
Lordship will also consider one particular point. Since the co-sharer is present, he has to he has a right to purchase the property under the law. The preemption law will coming into that. Whether in the subsisting offer, whatever the receiver has received, whether he is willing to purchase the entire property, comparing to the offer made by the others.
intending purchaser. That is also Lordship kindly
Lord, I
consider.
appear for the plaintiffs. I am filing my suggestions regarding valuation. And my lord, that with regard to the mode of sale, as was directed.
Lord, we both applicants are before my lord. There are.
Are you a co-sharer?
Yes, I am a co-sharer. He is not a co-sharer. I am 7B. I want to sell my share in the property so far as only 5 and 6 Shiv Narayan Lane is concerned. Lord, I have filed an application which is GA1 of 2013. Sorry, GA11 of 2013.
Sell your share.
Sell my share.
To the co-sharers.
No, my lord. To, my lord, any purchaser, but I have a purchaser with me, my lord, who is ready and willing to take my share. Not just my share, the entire property on an as is where is basis. Similarly, my learned friend has come up with an application GA19. My lord, time and again we had submitted before my lord that, my lord, these two applications are to be considered by my lord today. Nah, my lord, so my lord, today before
GA11
of 2013.
2013. So this application is filed by one of the co-sharers.
By me, 7B.
7B.
Yes.
Okay.
So, my lord, I am seeking permission because earlier, my lord, Justice I.P. Mukherjee had granted these kind of sales, my lord. On that basis, my lord, we have come up before my lord seeking, my lord, sale of my share. But, my lord, I have a purchaser who is ready and willing to buy the entire.
Oh, regarding so far GA11 of 2013,
yes,
you are ready and willing to sell your shares.
Sell, but I have a purchaser who is ready and willing to purchase that property on an as is where is basis.
Okay.
My lord,
Now,
may I, my lord, submit one?
you are
thing?
appearing for?
My lord, for the GA number 19 of 2024, my lord,
Yes.
and for the applicant, my lord, I am an intending purchaser. My lord,
in purchaser of the entire lot.
Yes, 5 Shiv Narayan.
5 and 6.
5 and Shiv Narayan Das Lane. My lord, my prayer is, my lord, for purchase of 5 and 6. 5 is now 6. Formerly it was 6, now it is 5. Premises number 5 Shiv Narayan Das Lane, formerly known as 6 Shiv Narayan Das Lane. 5 and 6, my lord, it is interchangeable. 5 and 6 are the same property. Now, my lord, so far as my learned friend is concerned, he is, my lord, for one of the co-sharers. My lord, his position and my position.
Question is now the question is, so far your shares are concerned, you have traced out an intending purchaser.
Yes.
And you have mentioned that in your application.
In my application, I haven't mentioned. I have mentioned, but
no. Your application is GA11.
GA11.
So GA11 was filed in 2013. And in that application, you have sought to transfer it to an intending purchaser.
I've sought leave from my lord to transfer it to an intending purchaser.
So far that portion is there.
Yes.
That means you see that purchaser comes.
That purchaser comes.
The issue is, my lord, if I may, my lord, clarify one point. My lord, he is a mouthpiece of the intending purchaser as well. So, my lord, my and his footing is not so different. And my lord, because he is the co-sharer, he is trying to sell, but to an intending purchaser. He is basically the mouthpiece of the intending purchaser.
Who is living in that
premises.
Question
is,
don't use
he wants to sell to an intending purchaser who is waiting for a long time. From 2013 he is waiting.
And he's there in the premises.
And my lord, his own shares. My lord, his shares.
Yes, confined to him.
His part.
He is confining himself to his own share, to a person who is waiting for last 12 years or whatever is this application is with.
Yes, my lord.
You have come recently.
I have come in 2019.
You have come in 2024.
Yes.
24. And you want to purchase the entire thing. Suppose his share is sold out. Okay. His shares is sold out. So you have to purchase the remaining shares.
But, my lord, I have come up with another offer, my lord, that though my prayer is limited to my share, my lord, during the course of arguments, we have submitted, and my lord, I don't believe it has been recorded that
so
we are ready.
Your application GA11.
Yes.
Which is not opposed by any of the co-sharers.
No, it's being opposed by the defendant who's appearing in person.
only one
Okay, are you willing to what purchase price?
Lord, my purchase price consists of the entire property, not just my share.
Your share, how much did the intending purchase that?
Lord, my share.
How much? Is there any offer letter?
Lord, we have on the last occasion in open court we have submitted, but that price was for the whole property, not just for my share. 81 lakhs for the whole property.
Your GA11.
Lord, my GA11 is Lord, with deepest of respect, my GA11 concerns my area, but Lord, subsequently when this applicant had come in seeking to purchase the entire property, my lord, I had revised my bid to 81 lakhs for the entire property, not just limited to my share.
This is only verbally.
No, it's not verbally. It is there. Time and again we are contesting.
What is your prayer in GA11?
My prayer in GA11, my lord, is regarding my area, which is 1/3. But my lord, today when there is an intending purchaser of the entire premises, my lord, I have a purchaser who is also willing to buy it at the entire premises at a very high rate.
So in that GA, you did not file any supplementary affidavits?
No, in this GA,
No, so
we can file, my lord.
But till
Tomorrow
then,
we can
the
file.
application for the purchase of whole property is my lord, I am preceding him because today if he comes up also, then it will be of 2025. I have come in 2024.
But my application is predated.
But only for a part of it, not for the entire property.
But if we go by that now, my lord, he is an outsider.
I
I'm a person inside.
I have for the plaintiffs. Now today I have filed one suggestions with regard to valuation and the mode of sale, as was directed by your lordship of the earlier occasion.
Yes,
My lord, my submission is this: best offer will be obtained
Yes.
if the bid is done in open court. Why? Before your lordship, because so many persons now have come forward to purchase, and the receiver has valued the property, which is valued at rupees 2 crore 85 lakhs. So 6370 is nothing.
No, 2 crore entire 85 lakhs is for the empty premises. That whole premises is tenanted.
Our offer is my lord, to buy it as
Is where is basis, so is my
With the
offer.
tenant.
So is my offer.
That is why my lord.
On an as is where is basis.
yes, what do you want to submit?
Yes, I want to submit my.
Yes, give it.
What are you? Do you have
Let
extra
me see.
copy?
Yeah, on the tractor, you know.
Have you served a copy upon other parties?
It has not been
Hey, আমার
circulated.
তো একটা নিয়ে
I
নাও।
was just now. Is
No,
not
no, no.
Serve it upon the other parties.
this.
এটা আমারটা। এটা plaintiff এর।
এটা the suggestion is by the plaintiff.
যেটা last দিনকে direction ছিল।
Regarding what I was asking, regarding your share, how much are you ready and willing to sell?
Lord, regarding my share, Lord, then Lord, there will be multiplicity of litigations. There is a purchaser who is standing in line who wishes to buy the entire
question
property.
is, if you are ready and willing to sell your share to the co-sharer defendant who is present in court, whether are you ready and willing?
I'm ready and willing if, my Lord, I get
But the question is, you will not get possession. Somebody is in possession of that portion.
somebody is in possession, and if I get the
And at
market
what
value,
capacity he is in possession?
he's a tenant.
That means tenant is ready and willing to purchase.
Tenant is ready and willing to purchase. I am a co-sharer. My purchaser is the tenant in the premises. He's not an outsider.
There are about 18,
And-
19 tenants.
And he has been a tenant for more than 80 years.
The tenant in respect of the whole property.
No, not in respect of the whole property, in respect of my property.
How much are you ready and willing?
My lord, our offer.
Entire suit property.
Yes, my lord, our offer was of 70 lakhs, which was negotiable.
70
We were open
lakhs.
to negotiation, yes.
And I've started with 81 for the entire premises on an as is where is basis.
But there is nothing in the record that you are ready and willing
Lord,
for
we will
81.
file a supplementary affidavit tomorrow itself. If that is the technical issue that they are
The
creating.
possibly, Millard, whatever my learned junior friend is submitting, that's a different contest altogether. If your lordship sees your lordship's order, lordship has passed a clear direction that whoever come up with a clear suggestion.
Yes.
Now, so far,
I'm 11.
GA 11 is concerned, the pith and substance of this application is that he wanted to sell out his property. Now he is saying, by modifying his this prayer, that he has a buyer ready to whom he will purchase the entire. If that be so, in that event, that would also appear before your lordship as a suggestion.
Yes.
Whatever your lordship has passed
as an
that will
offer,
also come up on
as
that
an offer.
event. Like Mr. Roy has passed, Mr. Day has given, it is also come up on that event. Then after your lordship go through the same, then it's up to your lordship to pass a necessary order. Otherwise, the entire things will be put into the whirlpool. Because the situation is that in one GA, he wanted to sell out his property. On the second GA, which is not before your lordship, he wanted to purchase the entire property as he has a buyer ready. On the other hand, Mr. Dotto also have an offer to purchase the property as is. What is his basis?
Now your offer is 70 lakhs.
70, my lord, from the day one, my lord, it was negotiable. My lord, we have clarified we are willing to go up.
We have started with 81. For the
So
entire
if you are willing to go up, then I can suggest one thing, another date be
Very well.
fixed.
Very well.
So that you can hold a discussion.
Lord, in the meantime, Lord, leave may be given. I'll file a supplementary affidavit because if these technical points, no, the because there's a purchaser in line.
Ultimate solution. Otherwise,
That means the special officer has to hold the auction cell.
No, my lord. That we are objecting, my lord. We want it to be in the court, my lord. We don't want it before the special officer.
No,
We
no,
have,
no, it
I
has
have
to be,
instruction.
because court will not take up these things. This
No,
sales-
Milord, it's Milord, we will give our offer, Milord, in sealed cover in presence of the court, and Milord, the bids will be opened.
Yes,
It's just the price that the court has to see, Milord. Whoever bids the highest will get the property.
May I just assist one?
No, as per the valuation,
2 crore
did you receive any offer considering the valuation?
Milord, valuation, time and again, Milord.
Is for the receiver.
I'm for the receiver.
Yes.
Milord, to be very honest, Milord, I have received Mr. Dotto's suggestions on the offer, and so far তোমাদেরটা এখনো তো আসেনি. It is on the pipeline, I guess.
Now, receiving the, considering the valuation, how much is the valuation?
Valuation is my year. If your lordship sees, it is already in the record, Milord. It is far above, and it is for unencumbered property, free land. And this property is, if your lordship sees, I will give them the photograph on the next date. It will give a clear picture that this property is not at all a free from all incumbent. There are tenants, there are dilapidated property, there are everything is out there. So that valuation cannot be applicable in self-similar application.
Milord,
That is my respectful submission.
The sum and substance is that the valuation given to my lord, which is 2 crore 85, will not be applicable in this case, because that 2 crore 85 is for a vacant land, Milord, where, Milord, it's unencumbered. This whole premises is fully tenanted. Even the share that I want to sell is tenanted. I believe there is no empty share, if I'm not wrong.
No, no, regarding the intending purchaser which you are bringing, he has offered 80 lakhs.
81 lakhs for the entire premises on an as is where is basis. There
Yes,
is no condition attached
So
to it.
far, Mr. Dotto's client is concerned, he has come out with 70
70
lakhs.
lakh.
And according to you, it should be an open auction sale.
Open auction.
Open auction. We are all agreeable to it. Open
Whatever,
auction.
whoever will give the highest bid, he will get the money. As is where is basis.
No, in this type of partition suit, you see, it is not a case of company code that the sale will be in the court. It is always before the special officer, not before the
When a
court.
receiver is there, it can be done.
Yes, yes,
with
yes.
the receiver.
Yes, yes, yes. So before going into that complication, I grant all of you an opportunity, some few weeks time, so that if they are ready and willing to go up higher, okay?
Yes, that can.
Or if they are ready and willing to go up higher, or if you can engage some authorized agents to ascertain as to if there are some prospective buyers, that also opportunity is there. So it's better you hold a discussion. In the meantime, if they can bring some intending purchaser, or if they can raise their offer, let them take an opportunity and let them file let him file a supplementary affidavit also.
Your lordship, just
Not
for
supplement,
Milord,
it will be a fresh, Milord, the suggestion.
Presentation in the form of an affidavit. In the form of an affidavit. Your lordship, just Milord, for Milord reference, kindly turns to page 16 of GA 19. There was an earlier order, Milord. Your lordship will find essence. Similar kind of prayers were made, but Milord, what was the modality that was adopted? Kindly turns to page 16 of GA 19. Your lordship, at the next page, your lordship will see what was the condition, or rather the modus operandi. At page 17, your lordship, the operating part of that order is. An offer was given, and time and again it was adjourned for Milord obtaining an higher order, higher offer. In the absence, Milord, the sale was concluded to the person who had bid the highest. Today, my lord, we will be approaching with the same kind of modality before my lord.
But so far your GA application is concerned, it is confined to your share.
My lord, I am saying that I will file a affidavit, my lord. If I'm caught on these technical points,
Otherwise,
at best I'll file a revised
file a
application.
fresh application.
Yes, I'll file a fresh application if that
It
is so.
transcends beyond mere technicality. When the
No, no,
plaintiff for
it's-
something, Lordship will pass an order.
No, no,
My
no, you
learned
file a
friend is
fresh-
an outsider.
you Make,
He
make that not pressed, then yes, record an order.
Your Lordship, let the application remain my G11. We will file a fresh application at the time of final consideration. My lord, that
So I am considering your suggestion that for auction sale, but let another opportunity be given.
Yes. Our application.
Learned advocate for the plaintiff. Plaintiffs and learned advocate for defendant number
7B.
7B. Learned receiver.
I am on behalf of
learned advocate representing the receiver. The defendant number 11 in person.
And the intending purchase.
Learned advocate,
GA 19.
learned applicant, learned advocate for the applicant in GA 19 of 2024. Yes, any other applicants?
No,
Okay.
I don't believe.
No, I have recorded in person.
Yes.
Are present. In terms of the earlier order, the parties have come out with a suggestion. Learned advocate appearing for defendant number 7B submits that his application GA 11 of 2013 be heard with some modification of the prayer. As it is submitted by learned advocate for the plaintiff, that an auction be held to get a reasonable price. This court is of the view that before passing an order for auction, one more opportunity should be given to the parties and their learned advocates, as well as the intending purchasers who have approached the parties, to sit for a discussion and thereafter renew their prayers and suggestions. Thus, this matter stands adjourned till 23/7/2025 for submitting further suggestions in this regard.
Extremely grateful. Our application.
Okay, learned receiver is requested to conduct the meetings with the parties and the learned advocates as well as the intending purchasers.
Millet, the only one difficulty.
Yes.
If your lordship is indicating to hold the meeting with the intending purchaser,
Who has appeared in court.
that I would do. But so far, Mr.
Alim.
Mr. Alim's clients are concerned. Who is
No, they have not appeared.
I have no clue on that event.
Intending with the parties and their learned advocates and the intending purchasers who is before this court.
Yes.
My lord.
Yes, my lord.
Grateful.
Very good. 23rd of July.
তোমার নাম দিয়েছে? My lord.
Plaintiff. উনি যেটা
Hmm.
দিয়েছেন সেটা কপি দেন।
My lord, he's whatever he has submitted before the honorable court, my lord, has not been circulated with us. No. Defendant number 11.
Yes, serve your copy upon the advocates.
Whatever has been, my lord, placed before this court. I'm grateful to you.
Item number 32.
Yes, not today.
Item number 33.
Yes, not today.
Item number 34.
Not today.
Item number 35.
Not today.
Number 36.
Not today.
Item number 37.
For the petition of I'm for the income tax department, my lord. My lord, One more.
7.
37.
Yes.
Defendant number 2. I'm for the special commissioner, my lord.
You are for?
I'm for the petitioner, plaintiff, my lord.
Which application is to be taken up
My lord,
today?
this application in this suit, joint special officer, joint special officers were appointed for receiving the dividends. Now, income tax department imposing tax upon them. That's why they made an application. This application should be heard first. And now,
My lord, kindly takes up this application after 10th July, my lord. My senior is not in court. He is ill.
Application by? This is an application
special officers.
by the special officer. Okay, copies of the application served upon all.
Yes. If the affidavit has been exchanged.
Affidavit exchange.
Yes, on the prayer of the learned advocate representing the income tax authority, the matter stands adjourned till 15/7/2025. The department is directed to put up all the GA applications which is appearing in the list.
এই আমাদের কটা অ্যাপ্লিকেশন আমাদেরকে সার্ভিস করা হয়েছে দেখে নিস কিন্তু
The department is directed. And copy of this order be sent to the registrar original site.
You obliged, my lord.
Number 38.
Your Lordship, I am for the plaintiff in this matter.
For the respondent petitioner, my lord.
But I appear on behalf of the joint receivers, my lord.
Your?
I appear on behalf of the joint receivers, my lord.
38.
I am led by Mr. Shen Gupta.
She was pleased to appoint a special officer.
This is my report, my lord.
One of the last order, my lord was pleased to appoint a special officer. It is a suit.
Last order,
The inspection was required to be done, and a report was to be filed. But the inspection has been done in presence of the parties, my lord, but the joint receivers were not present on the day of the inspection, my lord. Now, my lord, at the time of carrying inspection, we requested learned special officer to consider the report of the first receiver which was appointed, which is a
report is already circulated.
No, it has not been circulated. Let them circulate the report, Your Lordship.
Yes,
Let us
they got
consider
an order.
first, Your Lordship.
I am appealing for the joint receiver, but a report should also be given to.
Learned advocates appearing for the parties and learned advocate for the joint receivers and the learned special officer is present in court. Today is fixed for filing of the report by the learned special officer. As the report is filed, let it be kept with the record and the same be circulated to the learned advocates. Let this matter appear on.
No, no, it was, sorry to interrupt, my lord. It was not only for the filing of the report by the special officer. If my lord may kindly take up the report, it was also for the affidavits to be filed by the receiver and the plaintiff, my lord, which is pending since last 3 years.
So let us consider the report first, Your Lordship, because we have to consider.
Let me please.
This
Because there is
application.
No, the GA12.
the receivers are
12 of
represented,
22, my lord.
and your special officer is also represented.
My lord may kindly
Now
take up
says,
the order,
my
my
lord,
lord.
this special officer has filed.
Yes, on the last occasion, GA12,
Yes, my lord.
I think on the last occasion you were not present. GA12 of 2022 was heard and this order was passed on 19th May 2025. Okay. So, on the basis of this order, the receiver caused inquiry and submitted the report. Now the question is, after all, after considering the report, considering this report, this GA12 of 2022 is to be heard out.
My lord may kindly take up last order, my lord.
Yes, that is 19th May.
Paragraph number 6, my lord.
Paragraph number 6. Yes.
Thus, the learned receivers are granted opportunity to submit affidavits with regard to the said application GA 12 or 22. It is submitted by the learned advocate that the pending hearing of GA special officer be appointed to cause inspection. But
So far, one part is complete.
One part is complete.
But
last occasion also it was submitted by me, Millard, before your lordship. This GA 12 has been filed in 22, served, receiver appeared. Thereafter, he has not been taking any steps. Neither the plaintiff have filed any affidavit, nor the joint.
yes, so in terms of this order, one part is done.
One part is that
The other part is not done.
He is the special officer, Millard.
Yes,
He's
yes.
not the receiver.
Yes.
He has been only appointed to
For a specific purpose.
only a specific purpose.
Yes.
No, last date till date, Millard, no affidavit has been filed. It was my.
But if I am allowed to submit,
Yes.
I am praying for the time to file the affidavit so that I can deal with this report of the special officer also. Comprehensive affidavit needs to be filed, my lord.
So the stand of the receivers are very, very important, your lordship. The special officer.
This on affidavit. Let me
Okay.
see the report of the special officer.
An opportunity is granted to the learned receivers as well as, yes, and which you are
The plaintiff, your lordship.
and the plaintiff.
Yes, madam.
Only receivers and the plaintiff
Yes, receivers and the plaintiffs.
to file affidavit in opposition to GA 12 of 2022. All parties are granted opportunity to file their views, if any, with regard to the special officer's report. Reply, if any, to the affidavit in opposition to GA 12 of 2022 shall be filed on or before 11/7/2025.
Kindly give 3 weeks.
3 weeks
sir.
here
3
time.
weeks time, sir.
Okay, by 18/7/2025. Reply, if any. How soon can you file your reply?
Paragraph number 3 of the order, Millard, last, which is respect to GA 13, Millard. GA 13 with GA 14, it appears that pursuant to the orders at 8 March 24, whereby the learned joint receivers are directed to serve a copy of his report, Millard. We had filed GA 13 with respect to status of the fixed deposit and withdrawal of the same, Millard.
No, now with regard to GA 12,
all the 3 applications were heard on that date, Millard, and there is a specific direction to this also, Millard.
No, 14 has not been heard, your lordship. 14 is lordship 340 application which has been.
now I am taking
Joint receiver, Millard, please, Millard. The joint receiver were under direction under GA 13 to order dated 8 March 24, Millard, which was not complied with. What has been done, and the joint receivers were to apprise this court what steps they have taken, and as per paragraph number 4 of the order, Millard, to which we were directed to serve a copy of this order and the last order to the joint receiver, which has been done, Millard. But the joint receiver is being represented. What has been done? It is not before the court, Millard.
I appear for the defendant number 1, your lordship. Your lordship, it so happens that all 3 applications, GA 12, GA 13, GA 14, on my submissions being made on the last day.
This has been communicated to the branch manager. This will
Sir, anyway, let me
So
consider
there
this
is a copy. So we being the party to the suit are being given any letters what communication the joint receivers are having.
No, let me take up this GA 12 on the next day.
Yes.
Let affidavit in opposition be filed on or before 18/7/2025. Reply, if any, by 25/7/2025. Let this matter appear on 28/7/2025 at 2 p.m.
2 p.m.
Your lordship, if I may kindly indicate, I apologize for taking up your lordship's valuable time. Your lordship, I am for the defendant number 1 in this suit, your lordship. So, your lordship, this application has been taken out by the defendant number 2 for removal of the joint receivers, your lordship. Your lordship had given me the opportunity on the previous occasion when this matter came up to file an affidavit from our side as well, because our stance is very much in support of the application of the defendant number 2. If your lordship is kind enough to extend the time for us to file our affidavits to GA 12, 13, and 14 as well.
No, I am now taking this GA 12. If you want to file, you file it within that date. That is by on or before 18th.
Because earlier order, your lordship had given us liberty. I have drafted it, however, we have not been able
Okay,
to.
it is clarified. It is clarified that defendant number 2,
One.
defendant number 1 may also use an affidavit in GA 12 of 2022.
Now, this GA 12 is the directions are there, my lord. Now GA13, my lord. GA13 is also very important.
Special officer's report may be
GA13 regarding?
GA13 was regarding the status of fixed deposit which is being held by the joint receivers, my lord. We made communication, wrote letters, no replies were made to us. So we were
13 is part of 12.
no,
You
sir.
are also asking for removal of the discharge of the special
No, my lord. They are specific two prayers only, my lord, of GA13. my lord.
GA13 is for?
GA13 is for the status of the fixed deposit as to
This
what
will be indicated in the
sir,
affidavit.
sir.
Yes.
Please, sir.
So what is the present position of that application?
But the present position of there was a direction in terms of prayer A, my lord. Receiver was directed to file the status report, my lord. The learned receiver filed its status report with the copy of the fixed deposit before the court, to which we filed an exception, my lord. After receiving the exception, my lord, there was a direction to ask for the alleged for the siphoning of funds, my lord, in our exception on the receivers. Receivers were directed to call for a report from the branch manager, which is as per order dated of 4th March, my lord, 8th March 24, my lord, of GA13, which is in which category it was stated the communication has to be sent because as
Let me see that order, 4th March.
8th March 24, my lord.
Okay, 8th March.
And which has been mentioned in the last order also, my lord.
Let me see.
Yes, sir.
My instruction is, my lord, that this has been given to the branch manager.
The report joint receiver shall serve a copy of this report, exception to the branch manager for preparing the.
Yes. Regard to the order dated 9th March 2024, 8th March 2024, passed in GA 13 of 2023, whereby direction was issued to send a copy of the exception to the branch manager of State Bank of India, Personal Banking Division, Kolkata main branch, to submit a breakup and yearly accumulated interest since inception of the fixed deposit amount and deduction, if any. The report was to be submitted in form of statement of accounts in respect of the fixed deposit number 3050-4655645. Stop. As there was a direction upon the joint receivers to serve a copy of the report as well as exception to the branch manager, the learned joint receivers
Have already forwarded it to the branch manager on 16th of June 2025.
Submission.
Kindly record it.
shall obtain necessary report and clarifications as to what steps have been taken by the bank and what report is prepared with regard to the intimation sent by the joint receivers.
Kindly record the joint receiver in terms of your lordship's order 8th of March 2024 has forwarded on 16th June.
Yes.
Let a copy be given to us.
Yes. Upon obtaining necessary clarification about the steps taken by the bank and report prepared by them, the joint receivers shall collect the information and submit it before this court on the returnable date. So you have given the intimation?
I've given it to the bank.
Now you collect the information and the report and clarification and submit it on the court.
But kindly provide for a direction upon the branch manager to provide the necessary particulars. Otherwise, they will not be.
The bank
Branch
branch
manager,
manager
state
shall
bank.
also extend necessary necessary cooperation to the receiver and furnish the report and information.
This GA13 also be listed along with GA12.
So let GA13 of 2023
Yes, ma'am.
be listed along with GA12 of 2022.
Then your lordship allows us to also use affidavits.
No, that I've already stated.
For 13 as well.
I've given in 2022. 13 is very much necessary
Yes,
to
your
you.
lordship. Because the issue here is this. Under the order dated July 14, 2008, under which the fixed deposit was made, your lordship. Under that order, your lordship, the conveyance of the property, 100A and 100B premises number, was to be made in the name of the defendant number 1. So we are actually supposed to become the owners of the property, at least in name. Now, your lordship, 39 lakh odd was to be submitted into the court and to be made part of a fixed deposit by the defendant numbers 2 and 3, which related to the property. The intention behind the order being that once that security deposit is there with respect to the property, with relation to the conveyance. Now, your lordship, since the property is being subjected to mismanagement and waste, as the defendant number 2 alleges, as we, as defendant number 1, also wish to allege on record, your lordship, we need to also give our affidavit.
Okay, let affidavit be filed by the defendant number 1 to GA13 of 2023.
Yes. And also to the special officer's report, if we want to give our views, lordship gives us liberty.
I have given you two opportunities for while filing opposition. That report will also be taken into consideration by you.
Yes.
Deeply obliged.
Number 39. Number 39.
Yes, not today.
Item number 40. Item number 40.
Not today.
My lord, item number 40. I'm for appearing for the respondent.
Defendant.
Defendant. So, my lord, my senior, Mr. HON'BLE, due to some medical emergency, he is not appeared today.
Okay, then I'm fixing a particular data record. Learned advocate for the defendant is present. None appears for the plaintiff. However, the case stands adjourned till 23/7/2025. Learned advocate for the defendant is requested to intimate the learned advocate for the plaintiff by notice about the next date fixed. So intimate the learned advocate for the plaintiff.
Item number 41.
My lord, in item number 41, my lord, I appear for the plaintiff, my lord. I'm being led by Mr. HON'BLE Ghosh, my lord. He has to report some personal difficulty, my lord. Kindly fix it on Monday, my lord. He'll come and do it.
The defendant's advocate is not here. At what stage the suit is at present?
My lord, I think the WS has also not been filed.
Is the suit treated as undefended suit?
No, my lord.
Not yet. Okay.
This-
Record and order, item 43.
My lord, actually pertains to, my lord, the ex-chief minister of our state, my lord.
Yes.
The suit pertains to, my lord, the defendant is, my lord, the ex-chief minister of our state, my lord, Bhuttade Bhattacharya, my lord.
So,
So, my lord,
the suit has abated.
my lord, that's why, my lord, kindly Mr.
Okay.
HON'BLE takes steps accordingly.
Learned advocate for the plaintiff is present. None appears for the defendants. However, in the interest of justice, the case stands adjourned till 2nd August 2025.
2nd August.
Learned advocate for the plaintiff is requested to intimate the learned advocate for the defendant by notice about the next date fixed.
Item number 42.
Lord, I appear for the plaintiff in this matter. Lord, by your lordship's last order, the matter was directed to proceed undefended against the defendant numbers 2 to 7. Lord, on the last occasion, your lordship had also directed us to serve one more notice on the defendant number 1. My lord, we've served the notice, my lord. May I file the affidavit of service? My lord, repeated notices have been served upon the defendant number one, my lord. The defendant number one.
7
Yes,
was complete.
Yes, my lord.
Plaintiff number, oh, you are for the
Plaintiff.
Plaintiff number 3.
Yes, my lord.
Defendant number 1 has entered appearance.
Entered appearance, filed written statement as well.
Yes, yes. But and 2 to 7 have not entered appearance.
No, my lord.
Okay. This is with one more. There are 7 defendants.
Yes, my lord.
So far 1 is concerned, you are requested to serve one more notice upon
the defendant number 1.
Defendant number 1. So
Lord,
that you have served.
Yes, my lord. I have served and my lord tendered the affidavit of service, my lord. Apparently, they are not appearing even today, my lord, despite the notice.
So the question is, this thing, defendant number 1 has not filed affidavit. That is written statement.
My lord, written statement has been filed by the defendant number 1.
So complete the discovery and inspection in the meantime.
My lord, we sent the notice, my lord, on the last day. We had sent the notice only for this specific purpose.
No, question is, okay, that was for necessary inspection.
Yes, my lord. My lord, we served
It is not done.
No, my lord. Lord, since they are not appearing, my lord, my humble submission is that
it is fixed for settlement, framing of
issues, my lord. Yes, my lord.
Yes, record an order.
Since 2 to 7 already have been proceeded against.
None advocate for the plaintiff is present. None appears for the defendant. It is submitted by the learned advocate that in spite of service of one more notice upon the learned advocate for the defendant number 1 for causing necessary inspection, no steps were taken by the learned advocate. So when was the notice served?
My lord, I have been given affidavit. Lord, the notice.
14.
Lord, 14th June 2025.
14th June.
देखिए दिन है. Lord, I have tendered the affidavit of service as well.
Okay. The plaintiff has also filed an affidavit in service in this regard, and you have not received any response.
No, my lord.
In the facts and circumstances, this court is of the view that this case should be fixed for framing of issues. Let this matter appear on 2/8/2025 for framing of issues. Second office. Learned advocate for the plaintiff is requested to intimate learned advocate for the defendant by notice about the next date fixed.
Yes, my lord.
Item number 43. Item number 43.
Yes, not today.
Item number 4.
Lordship, item 44, I'm for the plaintiff. In this matter, Lordship, proceedings under the Insolvency and Bankruptcy Code has been initiated against defendant number 2 and 3. Lordship, I have also filed my proof of claim before the appropriate authority, which is pending adjudication, Lordship. Because of the provisions of the Insolvency and Bankruptcy Code, all the legal proceedings against the debtors have to be stayed. Lordship, I was only praying.
Adjourning this matter.
Lordship, I was only praying if the matter could go out of list with the liberty to mention.
Okay. Item 44. It is submitted by learned advocate for the plaintiff that proceedings has been initiated against the defendant number 2 and 3.
2 and 3, Lordship.
2 and 3 under Insolvency and Bankruptcy Code. Stop. Thus, let this matter go out of the list with liberty to mention.
Grateful, Lordship.
Item number 45.
Lordship, I am appearing for the
45.
Not today.
I am appearing for the plaintiff, Your Lordship, in 45.
Item number 46.
Lordship, 45, I am appearing for the plaintiff.
Yes, 45.
I am appearing for the plaintiff, Your Lordship. I was praying some more time to.
For the plaintiff, just a minute.
Yes, Your Lordship.
Yes. So, what is the stage of the suit?
Your Lordship, this suit was filed with respect to injunction and declaration that my clients are not entitled to pay the excise duty as claimed by Union of India. The matter had gone up to Supreme Court. The Supreme Court has given verdict in our favor. We are not entitled to pay excise duty on jute bags manufactured by us. So the Supreme Court has now, that verdict has been upheld. Everything is there, Your Lordship. The suit is now can be decreed on the basis of the Supreme Court order, Your Lordship. So I was only praying, Your Lordship, I have not received instructions, so that even I can give notice to the other side.
Yes, 4 weeks time.
4 weeks, maybe. Yes, Your Lordship.
Yes, record an order on the prayer of learned advocates for the plaintiff. The case stands adjourned till 28/7/2025.
Lordship would kindly give me liberty also to serve notice upon the defendants.
It is also requested to serve notice upon the defendants and their learned advocates.
Oblige, Your Lordships.
Yes, 46.
My lord, I appear for the plaintiff, State Bank of India. My lord, on last occasion, your lordship directed the plaintiff to file affidavit of document. But my lord, unfortunately, some of the document could not be traced now. My lord, I am praying some more time, my lord. My lord, they have also not filed their affidavit of document as yet, nor there is inspection completed. Well, although it was last chance, but unfortunately,
so long time ago, May 21st.
Well, kindly some time be granted so that we will, and direct also direct them to file their affidavit of.
Oh, they have not made any prayer.
We are the defendant.
They have done.
Carriage of proceedings is upon you.
Yes, record an order. Learned advocates for the parties are present. Learned advocate for the plaintiff prays for time to file the affidavit of documents, although today is fixed as the last chance. Let this matter appear on 23/7/2025, 23rd of July, for filing the affidavit of documents.
Kindly also direct them to file their affidavit on documents.
The defendants may file the documents in the meantime.
I'm grateful.
My lord, I am appearing on behalf of the plaintiff.
On behalf of defendant lordship, I am saying 2 weeks time lordship as the on the defendant lordship as a concerned officer, authorized officer has been changed lordship. So
Let me explain. My lord, in this matter, already the witness action has been completed. The matter is kindly, my lord, can fix for arguments actually.
It's appearing, 47 is appearing for arguments.
Yes. So defendants, there was a last witness of defendants, so they will resume the argument. So it's there. So they are. Will commence the.
Okay. Yes, record an order.
Kindly for time be fixed. It's already the matter was decreed.
Learned advocate for the parties are present. Today is fixed for arguments on the prayer of learned advocate for the defendant. The matter stands adjourned till 17/7/2025 at 2 p.m.
17th can be 18th, please, man.
18th is a Friday. Okay, then let it be 22/7/2025 at 2 p.m.
Grateful. Grateful. 17th of May, Grateful.
Grateful. 22nd.
Item number 48.
48 man appearing for the plaintiff. It is fixed under the heading witness action.
Yes.
Here the plaintiff's witness has been examined on commission.
Yes.
The commissioner has filed a report.
Yes.
The defendants were appearing.
Yes.
Defendant appeared before this court. In the commission also defendant appeared.
But halfway through the commission, the defendant's lawyer stopped appearing. Notices were sent directly to the defendants who entered appearance. There are many defendants, some of them entered appearance. Notices have been sent, and the commissioner has recorded in the report that halfway through the commission work, they stopped appearing. The commission work was closed. We took a leave of the earlier bench that we can proceed in their absence. Also, the orders are there. So today, I don't have any further witness. My only witness to prove my case has deposed. Now, it is kept for the defendant to adduce evidence or to appear before the court and say whether they want to.
Let me see the last order.
Last order down. Yes. This is my lord's order of 21st of May. Again, order. पूरा तो सर्टिफिकेट को भी लाइन लेते हैं हम डिफेंडेंट को क्यों कर देना तो जो ना
Yes, so matter is due to appear on 25th June 2025.
Today.
Yes, for witness action. That means plaintiff's evidence is over.
My lord, I will not adduce any further evidence. It is for the defendant to take a call whether they want to adduce further evidence. The commissioner's report is already on record.
Yes,
now, if the defendant is not appearing, my lord, so I will beseech your lordship to place the matter as arguments.
One more chance.
That I cannot stand in there. I should not stand in.
Yes, record an order.
Or I can send them a notice once again.
Yes. Mr. Mitro, learned advocate for the.
I've given notice and affidavit of service also.
Yes. Mr. Mitro, learned advocate for
appearing
the
defendants
plaintiffs is present. By in terms of order dated May 21, 2025, the learned commissioner already filed the report, and today was fixed for witness action. Stop. As Mr. Mitro submits that the plaintiffs do not wish to examine any further witness, let 16/7/2025 be fixed for evidence of the defendants. Learned advocate for the plaintiffs is requested to intimate the plaintiffs and as well as their learned advocate by notice about the next date fixed.
The appearing defendants, because they all have not entered appearance.
Mr. Mitro,
all the defendants have not entered.
Is requested. Mitro, learned advocate for the plaintiffs is requested to intimate the learned advocate for the defendant who is appearing
in this
suit, as well as the defendant who is appearing in the suit, by written notice intimating the next date fixed.
My lord's pleasure to record, because we'll save this letter order also, that if they don't come, the matter will play, the evidence will be closed.
Yes, if they don't come.
So that my lord's pleasure to record in this today's order, my lord.
Actually, it is not clarified whether today will be fixed for DW.
No, or she will record it, and she will record here in the next day. If the defendant does not appear, the witness, the liberty to give witness evidence will be closed, and the matter will be fixed for argument. That can be an observation of mine.
Of appearance, in default of appearance of the defendants, the matter will be fixed for argument.
Yes. So that message also goes, because I will send the letter also. 16th.
16. No, probably. Just a minute.
Witness. Oh, only one thing, man. 16. Only one thing, the commissioner has filed a report. Now, maybe take a certified copy of the report or copy from the court, because of what the commissioner has done.
He has calculated also.
He has circulated the report, not the deposition. We have the deposition, but it is not the final corrected one. So if the court's copy comes to us, we will carry the exact deposition. He has given the report without the annexure. Now we approached the commissioner. He said that you have it. We don't want any. There are some corrections made after. So liberty be given to
liberty to apply for certified copy of the report of the commissioner along with the depositions.
And deeply obliged.
My lord, I appear for the defendant. My lord.
Appear for the plaintiff.
Yes.
It appears to be a commercial dispute. Your Lordship, I am an unpaid seller of goods. So therefore, my lord, this has to be probably subject to.
So if it is a commercial dispute, then it has to be released from this bench. Yes. It is submitted by the learned advocates that the suit involves commercial dispute. Stop. Thus, this suit stands released from this bench, and the same may be placed before the bench, having determination.
Obliged.
49 না 51 51 ডাটা
এই এটা একটু দিয়ে দাও অ্যাপিয়ারেন্স ওখানে অনলাইন
51
অনলাইন করেছে অনলাইন
মিস্টার I'm sorry
অনলাইন
Mr. Ghosh Milord was in cross examination
But the plaintiff's witness, yes, Lord. The plaintiff's witness was being cross examined. The matter was fixed for 25th of this month.
Yes.
But the bench was not presided over by your lordship, so
Yes.
it has come up today.
Okay, let another date be fixed.
Yes,
But
my lord. That is what I was praying.
this was the understanding between the parties. I do not join issues, Milord. May I just request for one thing? There has been a bereavement in Mr. Ghosh's family, Milord.
Okay.
May I just seek for
Who
a
is representing?
Mr. Devnath Ghosh, Milord.
Oh, Mr. Devnath
Defendant.
Ghosh.
Defendant, he was in लिख दो.
Mr. Ghosh was
Leading
affecting the
he
Mr.
was
Devnath Ghosh.
yes, Milord. He was in cross examination. May I just
And Mr. Mitro was probably for the plaintiff.
yes,
Yes,
Milord. Mr.
I'm
Mittal
being led by
leading
Mr.
my
Honorable
letter.
Mitro.
May I, Milord, just seek for a date post 4 weeks? Now, I know this is an innocuous prayer, but Milord, had the situation not been so, I would not have asked.
Yes. On the prayer of learned advocates for the defendant, the matter stands adjourned till.
Milord, may I just seek one indulgence, Milord? Since both of us are ad item, may it be on the prayer made jointly by the parties, Milord. May it be subject to.
On the prayer of learned advocates
Very
for
well.
the parties, the matter stands adjourned till 28/7/2025 at 2 p.m.
Yes, Milord. Milord, for witness action.
Yes, for
The same
witness
heading,
action.
witness action. Grateful, Lordship.
Obliged, Milord.
Milord, in 52, I appear for the plaintiff, Milord.
Defendants, my lord.
Milord, on the last occasion, your lordship had granted us time to file the affidavit of documents. Milord, my humble submission is that there is some delay on our part, Milord. I was humbly seeking an extension of time.
This is the third time they are
Fine.
seeking adjournment, my lord.
Milord, the default is
Last
by
two
both
occasions-
parties, Milord. If your lordship kindly sees, Milord, both parties.
Given any letter for inspection to us, my lord.
Inspection? Milord, it was understanding. Milord, it was an understanding between the parties that once we file the affidavit of documents,
No
then
understanding.
only inspection and discovery of documents. will be
First
better.
is, my lord, the discovery and inspection, my lord, then
Milord,
affidavit
we have
of documents
also
has
not
to be
received
filed.
any affidavit of documents by the defendants. Milord.
Discover and inspect the documents, my lord. How can we file affidavit?
Yes, record an order.
First, kindly make this as the last chance, my lord. The third time they are seeking adjournment.
This is only the second extension
Learned
that I'm
advocate for the parties are present. Prayer for time is made by learned advocate for the plaintiff to file the affidavit of documents. The case stands adjourned till,
Kindly records my objection, my lord.
which is objected to by learned advocate for the defendant. In the interest of justice, the learned advocate, the plaintiff is granted one more opportunity to file affidavit of documents on or before 18/7/2025.
Milord, one more week, Milord.
Kindly makes this as the last chance for them, my lord.
On or before 31/7/2025. Let this matter appear on 2nd August 2025
my lord, in my last matter, my lord, your lordship had given 2nd August, my lord.
It will be easy for you.
Lord,
It will not cause you inconvenience.
Lord, 2nd August is perhaps a Saturday.
Yes, it's a working Saturday.
Grateful, my lord.
There will be less matters. It will be easy for you.
Grateful, my lord.
Kindly makes it on 4th of August, my lord.
You try on 2nd, okay. There may be other matters also.
Grateful, my lord.
Similar order, your lordship. Similar order. Similar matter.
Three?
Similar
prayer.
Same order.
Same order.
Okay, 53 same order.
Grateful, my lord.
Yes, 54.
54, my lord, I am for the defendant. Parties had exchanged the issues, suggested issues, and it was handed over also to your lordship. Today, the matter has come up so that the issues may be settled.
Yes, let me see the order.
আমার কাছে দুটোরই copy। আমার কপিটাই দিও না।
Lordship, it's a suit for eviction filed by me, your lordship. The bone of contention, the dispute is whether the tenancy is a joint tenancy or it's a single tenancy.
Whether it's a joint tenancy or it's a tenancy in common. That's the principal moot question. But over and above that, the first issue is whether this honorable court lacks inherent jurisdiction. Because if we are right in our contention, then it is below 10,000 rupees, the rent quotient. And therefore, it will be governed by West Bengal Premises Tenancy Act. Therefore, this honorable court would lack inherent jurisdiction. Initially, at the chapter 13,
What is that suggestion?
my lord, the suggestion, if I have basically evaluated both the issues which have been filed and exchanged, my lord, so far as my issues are concerned, issue numbers 3, 4, and 5 are crucial.
Lordship, may I just put the entire thing this way. Lordship, the plaintiff has filed 6 issues, 6 suggested issues.
Yes.
Defendant has filed 8 suggested issues.
You are for the plaintiff.
Yes, your lordship. Lordship, subject to correction, issue numbers 1, issue numbers 1, 4, 5, 6, 7, and 8, so far as the defendant is concerned, doesn't find place in the plaintiff's suggested issues. And plaintiffs, issue number 1 and 6 possibly are required to be there.
My lord, I will just try to simplify it because the issues are very critical and to be decided in trial. Now, regarding whether it is a tenancy that is governed by the principles of the West Bengal Premises Tenancy Act, that being the primary issue, apart from whether this honorable court lacks inherent jurisdiction, naturally, whether the notice which was issued under section 106 by the plaintiff is valid or not is a relevant issue to be decided. Now, that is my issue number 3, issue suggested by the defendant. If your lordship,
kindly,
there is some cancellation by hand. Whether the notice
my
dated-
copy.
Yes.
No, your lordship.
Maybe I have handed over to your lordship my copy. That is why it has gone like that. These are unmarked copy. I'm sorry if I have handed up to your lordship.
Lordship, kindly sees issue number 2 of the plaintiff and issue number 2 of the defendant possibly are the same. Just that the wordings, it has been worded
Yes,
in a different
I am not standing in the way regarding whether, in fact, the issue which has been suggested by the plaintiff is more straightforward. So I don't mind those issues coming coming in the foray. But with regard to issue numbers 3, 4, and 5, as suggested by the defendant, those need to be there because first and foremost, whether the notice issued under section 106 is valid or not, that is my issue number 3 as defendant. Then point number 4, issue number 4, your lordship will see whether there has been devolution of interest from the trustees to the beneficiaries in law. So this is a legal issue. And in fact, when the matter was before the honorable division bench, the plaintiffs, the added plaintiffs have been added here in the proceeding and amendment has happened. But regarding all the issues, those have been kept open. So naturally, this has to be decided, which is issue number 4.
These issues find
Yes.
place in your written statement.
Yes, yes, absolutely. In the amended written statement, I have highlighted issue number 4 also. Issue numbers 3 and 5 were there since the beginning. But regarding issue number 4, I have filed an amended amended written statement, and which was taken on record by this honorable court. Additional written statement, I stand corrected. So that additional written statement was also filed, where we have specifically taken this issue, and I have indicated the paragraphs of that amended plaint also, if your lordship will kindly see, that whether there has been devolution and or creation of interest in the subject matter of the suit in favor of the plaintiff numbers 6A, B, C, and D, or any of them, and whether these plaintiffs have a right to get a decree as alleged in paragraphs 11A and 11D of the amended plaint. So this is an issue which has to be decided.
Lordship, so far as the plaintiff,
Yes, both
your
were
lordship.
amended.
Lordship, so far as the plaintiff's issues are concerned, may I say this, your lordship? Issue number 1 is important, your lordship, because it is with regard to the monthly rent. So definitely that is going to decide whether the
Did the defendant dispute the monthly rent?
lordship, there is lordship. I'll just
It's connected to whether what is the nature of the tenancy.
Whether, you see, impliedly or explicitly, whether the defendant has admitted.
Lordship,
No.
may I just say this, your lordship? Lordship, the total sum of rent as contended by the plaintiff payable by the defendant is to the tune of rupees 1,90,075 and odd. Now the plaintiff is contending that this 1,93,000 to be paid by the defendant is in respect of a single tenancy that has been granted by 20 trusts in favor of the defendant. Whereas the defendant is trying to contend that no, there are 20 different tenancies.
Because the 20 trusts, I'll just indicate your lordship, the building is originally owned by Magma.
It's better you do one thing. If you have a copy of that amended plaint and written statement, you give it. I shall.
But it's in the record.
Indicate
You
one
have,
thing,
you have
lordship.
argued, you have made your submissions. Now let me consider.
Lordship, may I just
It's all in
indicate
the
this?
record, my lord. Those amended plaint and the written
No, if you
statement.
have a copy, it's better. I shall not carry the record. দেখুন তো আছে কিনা amended plaint.
Lordship, we don't have an extra copy.
I'm not carrying a
Lordship,
copy.
subject to what the defendant is saying, may I just say this, your lordship? Plaintiff's issue number 1 is something that will not find place in the defendant's issues, but is crucial for the purpose of adjudication of the suit as a whole, your lordship. Plaintiff's issue number 2 is equivalent to defendant's issue number 2. Lordship kindly takes note of the thing that issue number 2 of plaintiff and issue number 2 of defendant are common, your lordship. So far as plaintiff's issue numbers 3, 4,
written statement and amended plaint. Amended written statement তো আছে আচ্ছা আচ্ছা amended plaint
বলেছিলাম addition আমাদের গেছে এখানে amended.
Lordship, so far as plaintiff's issue numbers 3, 4, and 5 are concerned, possibly that is equivalent to defendant's issue number 3, just that we have subdivided into 3 parts.
No, I don't quite agree with my learned friend there.
3?
My lord, issue number 3 suggested by defendants should come in, because we are saying that whether the notice is at all valid or not. So that is a direct issue, because if it is a tenancy which is not governed by West Bengal Premises Tenancy Act, then it is right on their part to have issued under section 106 of the Transfer of Property Act. That is why it's a bone of contention between the party whether the notice itself is valid or not. And what my learned friend is submitting before your lordship is the suggested
And
issue
this is
number
issue
3.
number 3,
If
your
your lordship sees whether the monthly tenancy in favor of the defendant has stood validly terminated by
If
the
the notice is not valid, it cannot be validly terminated.
Absolutely that. So it's not
Yes,
exactly
unless the notice is invalid, it is not validly
Absolutely
terminated.
correct. So that is why, your lordship, this notice, whether it's valid or not, is a direct issue which has to be decided, and that is why I'm harping on issue number 3 suggested by the defendant. Regarding issue number 4,
Lordship, plaintiffs issue numbers 4 and 5, Lordship, I beseech your Lordship if those can be kept. And 6 is definitely something which is related to the main relief of the plaint, so it has to be there. So, Lordship.
I am not even, I don't know why my learned friend is getting so jittery, because I am not even submitting that these issues are not relevant and should not be gone into for trial. But with regard to my 3 issues on which I'm harping are 3, 4 and 5, which should come additionally with all the 6 issues suggested by my learned friend.
I agree to that. I agree
There
to that.
shouldn't be a problem at all the 6 issues suggested by the plaintiff coupled with 3, 4 and 5 of the defendant. If they are formulated, then we'll together have, I think, 9 issues.
Yes.
9 issues and the suit can stand for trial.
And Lordship, additionally, I think issue number 6 of the defendant, that is something that is not there in my suggested issues.
That's
but
your folly. But so far as my 3 issues are concerned, I'm harping only on 3, 4 and 5 for the moment.
So, Lordship, both parties are ad idem that issue numbers 1 to 6 as suggested by the plaintiff, 3, 4, 5 and 6 of the defendant.
6 I'm not submitting. I'm not even pressing 6 now. 3, 4 and 5 of the defendant.
So, so far, 2 of the issues suggested by both the parties are same.
Yes, more or less, yes. So,
now, so far 1 is there, it is necessary. And
Yes.
so far, issue number 1 of the defendant.
Yes, Your Lordship, this is necessary.
this is regarding 1 and
There is similarity with regard to 3.
I'll just indicate your lordship, issue number 2 of the plaintiff is similar to issue number 1 and 2 of the defendant. So if issue numbers 1 and 2 of the plaintiffs are taken in, and as well as 3 of the plaintiff, then 1 and 2 are covered. So far as defendant's suggested issues are concerned.
No, but this 3 and this 3
Yes.
have similarity.
Yes, also. 1, 2, 3 of plaintiff is similar to 1 and 2 of the...
No.
They say that it's 2.
1 and 2,
terms,
yes.
we say
हाँ,
that
সেটা
it is
বলেছি।
valid.
Now, my point number 3 has to come in, whether the notice itself is valid or not. Because unless and until it is valid, they are presupposing under suggested issue number 3 of the plaintiff that the notice is valid and therefore it's validly terminated. I am just striking at the root of the issue, challenging the notice itself. So whether the notice is valid or not has to be decided as an issue, formulated as an issue.
So regarding 1 and 2, according to you, this
The
2 is
plaintiff-
common. 2 is common.
Is common,
Yes, Your
yes.
So either of the 2, either of the 1 can be
Yes,
taken.
yes, Your Lordship.
Yes, record an order. Learned advocate for the plaintiff and plaintiffs and learned advocate for the defendant is present. Hard learned advocates. Learned advocates have also filed suggested issues and have made their submissions on the same. Stop. Learned advocate for the plaintiff has suggested 6 issues, and learned advocate appearing for the defendant has suggested 8 issues. Upon hearing the learned advocates and considering the issues suggested and the nature of the suit, this court is of the view that the following issues may be framed. Following issues should be framed. Thus, the following issues are being framed. Achha. Number 1, what is the monthly rent payable by the defendant in respect of the suit premises? Number 2, what was the number 2, whether the plaintiff trusts jointly created a tenancy in favor of the defendant as alleged in paragraph 5 of the plaint, or whether there were 20 different monthly tenancies created by the plaintiff trusts in favor of the defendant as alleged in paragraph 22 of the written statement. Stop. Number 3, whether the monthly tenancy in favor of the defendant has stood validly terminated by notice dated May 16, 2013. Achha, whether the monthly tenancy in favor of the defendant has stood terminated by a valid notice dated May 16, 2013. Number 4,
My
does the
my
defendant...
lord, may I just
Yes.
intervene? It should at least go in the form. That is my submission before lordship to be considered. That whether the notice is valid, because if we formulate it in the way that whether it is validly terminated under the valid notice, then
That means it is presumed that
then
the
it is
notice...
presumed that it is already valid. But I am questioning the validity of the notice itself. That is why, my lord, both the threes may be kept. My
Achha,
three
whether the
preceding
monthly
the first.
tenancy
Yes.
in favor of the defendant has stood validly terminated by the notice dated May 16, 2013. Next, whether the notice dated May 16, 2013 is valid.
Yes.
Next, এটা বোধহয় 5 নম্বর হচ্ছে।
হ্যাঁ,
Does the defendant have any right to remain in occupation of the suit property on or after June 3, 2013?
My lord, prior to that, 4 and 5 of the defendant's suggested issues should come in because
I'm
those are
taking
questions
that.
of maintainability.
Yes, I'm taking that. Whether there has been devolution and or creation of interest in the subject matter of the suit in favor of the plaintiff, numbers 6A, capital A to 6D, or any of them, and whether these plaintiffs have a right to get a decree as alleged in paragraph 11A and 11D of the amended plaint. Next. এর আগে এটা দিয়ে দেবেন। আচ্ছা, next, whether the defendant is a trespasser in respect of the said premises on and from June 3, 2013. Yes, instead of 6, I'm considering 4. I think your purpose will be served. Instead of your 6, I'm considering the defendant's issue of 4.
Should kindly keep 6 also, because
Okay.
that is my main
Next,
prayer.
whether the plaintiffs are entitled to a decree of eviction. Achha, just a minute.
Well, basically, 6 is covered in 4. 6 is covered in 4. Whether this plaintiff get a decree as alleged in paragraph so and so, it's covered. 6 is covered in 4. Is the same thing, entitled to a decree for eviction, and if my learned friend places before lordship the paragraphs
Okay, I'm
11A
just
and
giving
11B.
both.
Very well.
Although, para 6টা দিয়ে দিন, 6টা লিখেছেন যেটা,
Hmm.
whether the plaintiffs are entitled to a decree of eviction of the defendant from the suit premises. আচ্ছা তার আগে এটা লিখে দিন, whether this court has the jurisdiction to receive, entertain and determine the suit.
Yes.
Stop. Whether the defendant is liable to pay mean profit. Whether the suit is bad for non-gender of necessary parties. এইবারে চলে আসুন। Whether the defendant is a trespasser in respect of the said premises on and from June 3, 2013. And last, whether the plaintiffs are entitled to a decree of eviction of the defendant from the suit premises and delivery of vacant and peaceful possession hereof to the plaintiff. Next, what are the reliefs the plaintiff is entitled?
Lordship, may I just make one
Yes.
submission, Your Lordship? Lordship, my issue number 2,
Yes.
which possibly Lordship has been pleased to keep their issue number 2.
Yes.
Lordship, I think my issue number 2 is more comprehensive because their issue number 2 is basically summing up the contentions of both the parties, and my issue number 2 is just saying what is the nature of the tenancy.
No, my
which
lord,
will-
this is very tricky. I'll just indicate. This is very tricky. Nature of tenancy can be anything, but with regard to my issue number 2, it's specific to the pleadings made by the respective parties, where both the parties are joining issue with regard to whether it's a joint tenancy or it's a tenancy in common. It's a very specific case because I'll indicate at this stage of chapter 13A, my learned friend had obtained a summary decree against my client. And thereafter, when it went up in appeal, this was one of the issues which were formulated in appeal there. And they carried it up before the Honorable Supreme Court and it was rejected. So it stood fine, it attained finality. So that is why my issue number 2 has to remain.
Lordship, in that case, I would beseech your Lordship to keep my issue number 2 as well.
আচ্ছা আইটেম 2 এর পরে আরেকটা করে দিন তো 3 তাহলে একটু হোয়াট ওয়াজ আইটেম 2 করা হয়েছে তো 2 এর পরে 3 করে দিন what was the nature of tenancy created by the 20 trusts in favor of the defendant? Yes. Okay.
I'm extremely clear.
Sid. No, এই appellate side. আচ্ছা এটাতে তাহলে কি later next date we fix? আচ্ছা liberty to mention. Liberty to mention. Yes, call the appellate side matters. এগুলো রেখে দিন. appellate side এরিয়াটা কোথায় লিস্টে?
Your Lordship, I had prayed for an typographical error, Your
Lordship,
Lordship.
that is not typographical
Your-
error. She
Your
is trying
Lordship.
to change her submission. Kindly.
Your Lordship, I may be allowed to
Whom are you
submit.
representing?
I am the applicant number 2 in person in the revision application.
Your Lordship, they had
Applicant
filed
number 2.
In person.
they had filed one application during the vacation bench in which I had appeared. I am the de facto complainant, Your Lordship. Here the order has been
No, why this matter is appearing? Only this contempt
just
application.
for this just for the correction of this mistake, Your Lordship, because they are taking wrong advantage of this mistake. The learned advocate
Did the
for
same
the
before the court, Lordship.
No,
Now she is telling
this
that
matter-
I am taking wrong advantage.
I am the de facto complainant.
list name. Huh? So let this matter be.
Your Lordship, just correction may be done, Your Lordship.
Lordship,
And-
she
Correction for what?
Lordship, she is praying correction of the order passed in CRR.
No, not
The
in
vacation
CRR,
bench, 5th
not
June.
in CRR,
Cran
Lordship.
1 of
Cran
2025.
one.
She-
And one is for what?
For learned advocate for the de facto complainant, Malavika Shah. I am the de facto complainant myself in person, Your Lordship. So the learned advocate word may be removed because
Okay, that can be done.
that and another one,
That
the
is,
third-
and one is for
Uh,
necessary rectification.
They had,
No, Lordship, CRAN 1 is for stay filed by me.
your lordship,
That was being heard by your Lordship during the vacation bench.
No, question is, this matter is not a part-heard matter. So why it is appearing before this court?
Yes.
That is the
lordship,
So
for
this matter will go to the regular bench.
yes, your
Yes,
lordship,
Lordship.
for CRAN 2, which I had filed.
CRAN
here
2 is
up-
for
CRAN 2 is for expeditious disposal of the
no,
proceedings.
it
that
will
is the
go- it
merit
will
of
go
the
to the
case. That
regular
will be
bench.
heard by the regular bench.
Let me finish, your lordship. I am mentioning for the removal of one word where it is mentioned that adjournment, liberty to pray adjournment,
দেখি,
but
order
no,
টা দেখি, last order.
yeah, this,
Order.
but no such adjournment is granted.
That
Here-
was her submission, Lordship.
Here, your
Now
lordship,
she is changing her stand that was my submission because the learned court below has reprimanded her
your
in the
lordship,
prior date on 8th
your lordship,
July.
he never
18 June.
allows me to speak, your lordship. It was my mentioning.
Where is that application? CRAN 1?
CRAN 1, maybe senior lordship, it was their application that the court
Okay,
is not
you are-
granting
You are now just seeking a rectification
Yes.
of the order instead of for de facto complainant. It should be
only complainant, de facto complainant, not learned advocate.
Lordship, within the
And third sentence, your lordship, this was their prayer that pray for adjournment, but no such adjournment is granted. Actually, adjournment has been granted, and it was my submission that
it was there. The petitioner shall annex the copy of the order.
That was direction upon
They had-
us, Lordship.
they had not come.
But whatever she is submitting,
Where
on that day she has submitted that adjournment has not been given.
No, I had never sought that.
That's why learned
Lordship.
court below on the date fixed of
confusing
18 June, Lordship.
Question is now the question is
My order, the order of the honorable court is already.
She is trying to
CRAN
change the submission, Lordship.
2. এই যে CRAN 2 ওনার রেকর্ডে আছে।
CRAN 2 টাতে কোথায় আছে?
CRAN 2 টা তো আজকে নেই।
Lordship, changing of submission cannot be rectification of order, Lordship. Kindly
Wait, I
consider.
am confining myself to
Just
this matters on the
CRAN
record.
1 only.
Yes, Lordship, she is trying to change the submission
Because-
by way of rectification.
because
That is my
CRAN
objection.
was their prayer that the learned court has not granted adjournment as per the direction of this honorable court, which was granted in 18/10/2024. Now, while making this submission, I made prayer that the learned court had already granted 4 adjournments for 6 months, but mistakenly it
That
was
is why I have passed the order. The
Yes, Lordship.
petitioner shall,
Yes.
Yes, Lordship.
in order
That
to
is
prove his
Yes,
submission,
yes.
contention, I have directed
To
petitioner
annex
shall
certificate
annex a
copy.
copy of the order
Annexed.
where adjournment was refused.
Yes, they have
Exactly, Lordship.
closed, but they have filed a contempt petition against the learned magistrate, your lordship. Just the word, but no adjournment. This was not my prayer. This was the prayer of the petitioner. who
But
had filed
her
the
submission
CRAN
has been
application.
recorded, Lordship. She is trying to change the submission. That should not be permitted.
Only thing, some rectification is to be made in
Yes,
this order.
yes, your lordship.
Yes, record an order.
After going through the CRAN application, the prayer of the petitioner itself proves that this was their prayer, your
Yes,
lordship.
de facto complainant.
When I am the complainant, why should I seek
Lovika Saha, who
adjournment?
is appearing in
Yes.
appearing in person, and Mr. Romit Dotto, the petitioner number 2,
কিন্তু দেখাচ্ছে
are
দুটোই
both
আছে, দেখুন।
present. MS Shaha submits that in order dated 5/6/2025,
আমি দেখিয়ে
it
দিতে
is
পারবো।
recorded that she is appearing for de facto complainant,
কপিটা দেখালে হবে?
but she is the de facto complainant.
Yes, Lordship. In person.
I'm the complainant.
Thus, necessary rectification be made in order dated 5/6/2025.
She, your lordship. It should be she. I am the de facto complainant.
No, I have directed that necessary rectification be made in order dated 5/6/2025.
And no, but
Grateful,
no
Lordship.
adjournment should not be there, your lordship. It should be removed.
Okay. So with regard to this CRR, okay.
CRR, I'm not.
No.
No. CRA, CRAN 1.
With regard to CRR, as this court does not have any determination,
Yes.
CRR 4570 of 2024 may be placed before the bench having
Yes.
determination.
I have already mentioned it, your lordship. That word but no may be removed because they,
Grateful,
are
Lordship.
they have already filed one application on the basis of this small mistake, your lordship. What they are saying that I have made prayer that adjournment is not granted by the learned
That is
magistrate.
why I have directed. But
Yes,
anyway,
Lordship.
as because this court does not have determination,
CRAN 1
That much
may be
rectification,
rectified, your
that much.
lordship. Only order of CRAN 1 may be rectified. CRAN,
no, I have recorded necessary rectification be made.
oh,
I have directed.
deeply obliged, your lordship. Deeply obliged. Deeply obliged.
Grateful, Lordship. Bow down.
Two, I beg to differ on behalf of the
No, I am
petition.
for the opposite
Plaintiff
party.
petition. Last occasion, your lordship was pleased to direct, my lord, the opposite party to file their affidavit in opposition.
Give me 1 day time, my lord.
This is sir,
Or by tomorrow.
No, is this matter part heard?
No, this is not part of matter. What is the
So,
matter?
yes.
assigned matter, my lord.
Who assigned matter?
Last occasion, and my lord was pleased to direct them to file opposition. A short opposition, my lord. My lord,
One day time,
may,
my lord.
may I submit one thing, my lord, subject to your lordship correction, my lord. This is a very short matter, and my lord, therefore, no requirement of my lord exchanging affidavit is necessary, man.
Since there is already an
very
order,
short.
my lord. Can you see that, my lord? Can I take next date, my lord? Any date?
On 13th June, my lord, they're supposed
No,
to file
was
their
there any
opposition.
direction to file affidavits in
Yes, yes.
opposition?
Last occasion,
Which order?
Last order.
my lord, on my lord 16th May. 16th May, the order was passed.
You are for the opposite party?
My lord.
Yes, record an order.
On 13th June, they're supposed to file their affidavit in opposition, my
It is ready, my lord. Kindly take it
Learned
tomorrow, my lord. It's ready.
for the parties are present, heard learned advocates. As prayer is made by learned advocate for the opposite party. Opposite party number?
All opposite
Oh, opposite parties
They all opposite.
to file
কিন্তু রেকর্ড করেছিলেন
affidavit in opposition.
আপনি রেকর্ড করেছেন
The matter stands adjourned
All
till
opposite party না। কতগুলো opposite party আছে?
Such prayer is allowed. Let affidavit in opposition be filed by 11/7/2025. Reply, if any, by 16/7/2025. Let this matter appear on 18/7/2025.
Grateful, my lord. My lord, kindly make it as preemptory, my lord. Otherwise,
Yes, yes. On the next day, no further time will be granted.
my lord, online will be sufficient, my lord. If your lordship may please.
Okay. This dedication is peremptory.
Grateful. I'm grateful.
This is my application.
Now for the opposite party number 1.
This matter, my lord, is assigned to your lordships. Search. Give your service.
One.
नीचे बसो 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 बोल बोल
Yes, you are representing?
Yes, I am for the petitioner.
Petitioner plaintiff.
Yes.
You are
And for the
representing?
opposite party number 1.
Where is the order under challenge?
But here, but I have challenged the impugned order, which is annexed last page. At page, order number 90 dated 23rd September 2024. May I read out? Yes. Lord, before going to this order, Lord, may I just indicate one line. Lord, this matter relates to the preemption of the Muslim property. Here, Lord, I filed a suit for preemption in respect of the property. Lord, this matter was heard for a considerable period since 2012. My learned friend's client appeared in this suit initially and submitted Lord, the Mokaddama of his client, Lord, client. Thereafter, Lord did not take any steps. After 13 years, he appeared and filed written statement which was allowed by the learned court below. This is one grounds. And another thing is that the particular respondent number 1 or opposite party number 1, Lord, whose Lord application has been allowed after 13 years, he is not at all the necessary party because my principal grievance or Lord, the relief sought for against the defendant or respondent number 11 and 12. On this two score, Lord, this revisional application was admitted when it was Lord first taken up. If your lordships kindly have a look of the order first. Lord, that was passed on 21st February 2025, passed by this honorable court. Thereafter, Lord, I am come to state away the impugned order. 21st February, your lordship got it?
Yes, yes.
21st February 2025.
Yes.
The plaintiff in a suit for preemption under the Mohammedan law are the petitioners before this court. By the impugned order, the learned trial judge has permitted the defendant number 1, opposite party number 1 to file his written statement after 13 years from the institution of the suit. It is submitted by learned counsel for the petitioners that the relief sought in the suit is primarily against opposite party number 11 and 12. And as such, it is doubtful whether the opposite parties had any locus standi or justification for filing written statement. Thus, a strong prima facie case has been made out for hearing of the revisional application on the issues as to whether the learned trial judge was justified in permitting the defendant, opposite party number 1, to file his written statement in suit after a long lapse of 13 years, and as to whether, in view of the primary relief being sought against the opposite party numbers 11 and 12, the opposite party number 1 ought to have been given opportunity to file such written statement at such belated stage of the suit. Thereafter, Lord, the directions for service of notice, Lord, the other opposite party service is dispensed with, and Lord, the entire proceedings, my proceedings has been stayed.
What was the relief claimed by you in the suit?
In this suit, my relief is, Lord, your lordships kindly have a look of the plaint. I have not annexed, Lord, if your lordships kindly have a look of the plaint here. This is the plaint of the suit. Amended plaint. Copy ache?
Yes.
Your lordship kindly see the relief.
Is the defendant number 1 a pro forma defendant? Just.
Yes, just pro forma defendant.
No, have you stated him to be a pro forma defendant, or you have made him just a defendant?
No, defendant. There is no scope of pro forma defendant. In the civil procedure court, there is no concept of pro forma defendant. Only the scope is defendant.
Yes, but
Defendant,
parties are at.
Only questions is twofold.
No, sometimes if we don't seek any relief, you make him as a pro forma defendant.
We do that. We do that.
What is your contention against this defendant?
Milord, since Milord, he was one of the co-owners of that property. That's why, Milord, we have made party just like 2 to 17 or other opposite parties. But the cost, relief, Milord, which I sought for against the 11-12.
11-12 are the new purchasers.
Yes. They have purchased the property. We not paid for preemption against them. 11 and 12. Not against 1. Primary relief sought for against 11 and 12. So, after 13 years, can it be permitted the respondent number 1 to file its statement?
What was the ground taken in his application?
Lord, I'm coming. Lord, I'm coming. Your lordship, kindly have a look of the first. Lord, they have filed one put-up petition. Kindly see. This is very interesting. Your lordship, kindly have a look of the page 15 of my revisional application. Lord, kindly see this. They have filed the put-up petition, then along with the application for vacating the expert order. Thereafter, that was allowed by passing the impugned order. Your lordship, kindly come to annexure AP 15. Now, this is the put up petition, number 1. A separate petition praying for vacating the ex parte order against the defendant number 1 has been filed along with this put up petition. That one so and so institute the instant suit for declaration of preemptive right and injunction against the defendant number 1. Kindly see. But my prayer is saying something. And others. The defendant number 1 also appeared in the instant suit. Subsequently, the said so and so died leaving behind his legal heirs and successors who are the presently plaintiffs in the suit. That as the previous learned advocate for the defendant number 1 failed and or the defendant number 1 to take proper steps, the learned court was pleased to proceed ex parte against the defendant number 1 for 13 years. That if the defendant number 1 has got any knowledge of the above said order of the ex parte dated so and so, then would appear before this learned court on the next date and took proper steps. Well, can you see that? This is that the defendant number 1 is willing to contest the instant suit for the interest of justice. So and so. This is the put up. Now, your lordship kindly come to the petition. Kindly see, this is very interesting. So and so, number 1 paragraph, so and so instituted the instant suit for declaration, so and so, so and so. Now, 2, that in the month of April 2024, the defendant number 1, namely so and so, had instituted title suit. He is telling about the another suit. He is telling about the another suit against the Carno Block Private Limited, so and so, so and so, so and so. And subsequently, the plaintiff has filed one petition, order 39. He got injunction against that company. He is telling that. Paragraph 1, 2, and 3, you will also see that. Paragraph 2 and 3 are not related to the instant case.
But it relates to the suit property.
Yes.
Does it relate to the suit property?
That is related to the suit property. But he is telling, he is filing this petition for setting aside the ex parte order by telling the facts of the another suit which he has filed. Then grounds, kindly see the grounds. Next paragraph, page 17.
Yes.
That presently the defendant number 1 knows from a reliable source. He appear, his advocate appear after filing of the suit and getting the injunction in respect of the same property. He came to the rule from the reliable source. Kindly see that the said so and so through its main agent is trying to sell the schedule of the property. This is absolutely wrong. Because I filed this preemption against the Carno. So unless and until I got the order from the court, this Carno cannot transfer the property. Cannot transfer the property. Because I filed this suit against this 11 and 12. So unless and until the matter is decided by the learned court below, he cannot transfer. On the wrong impression, he got the injunction against this. And that is also not related to me. So far, the explanation with regard to the 13 years I want to look into. Why, my lord, the court will allow him to file his written statement after 13 years? That is the main primary thing of this petition. Who has filed the injunction, another suit, that is not the subject matter. He has to explain. Next paragraph 5. That after the defendant number 1 has inquired the instant suit before the learned court and found that the instant suit is still pending before the learned court, but ex parte against the defendant number 1. When it came to the knowledge, nothing. How he has came to know, nothing. Absurdity. Then, that actual fact is that, now he has come to this point, actual fact is that after getting the court summons, the defendant number 1 appeared in the instant suit by engaging a general advocate who filed the power Bokolatnama. That after appearing in the instant suit, the deceased plaintiff and the defendant number 1 made an. Now the story has come to that. Amicable settlement through their advocates regarding their dispute. First of all, first ground they have taken amicable settlement.
No, did they file any application for acceptance of the written statement? Written statement was there in the court's file?
No.
And accepted?
No.
Simpliciter time?
Yes. Simpliciter time for 13 years.
No. When the date of the order
yes,
was the defendant ready with the written statement?
No. The court was pleased to direct them to file the written statement with a cost of rupees 10,000. After 13 years. And look, kindly see the grounds. First of all, he has taken the grounds that there was a settlement talk. Lord, kindly see.
No, settlement in which case? The case filed by this defendant number 1.
No, in the instant case, there is no proof, nothing. I will show to your lordship the order impugned. Lord, first paragraph 7, kindly see paragraph 7 at page 17 of my revisional application. First case made out that there was a settlement. There was an amicable settlement talking. That's why, my lord, they did not appear. This is first ground. Lord, second ground, your lordship, kindly have a look of the paragraph 7.
What your contention was, this person is not the co-sharer who sold.
Twofold. First of all, at present he has no right over the property.
Your case is that you are one of the co-sharers.
Yes.
And the other co-sharer sold the property to a third party.
This person sold the property to that person. The opposite party number 1 defendant has sold the property to 11 and 12.
Oh, this defendant number 1.
He has sold out the property. He has sold out the property. Defendant number 1 has sold out the property to 11 and 12. Because of that, he is in party.
You see, it is not that he has come to apply him to implead himself as a necessary party or a proper party.
No.
It is
I have made him party because.
So why do you want to deprive him of the right to file written statement?
It is not permissible.
Maybe you will be compensated with costs.
No, I am, because only 15 years have gone by this.
No. What is the present stage of the suit?
Goes to final hearing.
No, final hearing means what? It is in the argument stage.
Yes. Final hearing. Preemption case, your lordship knows, final argument. And moreover, Lord, since he has transferred his right as an interest over the property, Lord, he has no locus at all. Only I have made him party just since in the earlier occasion, Lord, he was the owner and it subsequently transferred.
No, suppose the order is passed, transferred, and he's imposed some costs, heavy costs. So he will have to bear the cost that it is a malafide act. Suppose the court holds wrong and malafide act on the part of this defendant number 1. So he may be imposed some costs. If the court holds that the act of this defendant number 1 is totally bad, because ultimately this act has to be held as a good or bad. Okay.
Yes.
Either the act has to be held good or the act will have to be good.
Right.
Suppose the court imposes heavy costs upon him. That yes, it is your liability, you pay costs. The suit is allowed with costs, then you will have to bear the costs. That is the thing. It's not that nothing will go against him.
No, question is not how, but allowing this application for expertise order, vacating the expertise order will cause irreparable loss to me.
Now the case is appearing for further argument.
Further argument. At present, the matter stayed because the order passed by this honorable court. Last 2-3 days, 2-3 days, the matter. But questions is, there are two things. Your lordship can consider. Two things your lordship can consider. First of all, whether this at all the admission of this respondent number 1 or opposite party number 1 is at all necessary in deciding the issue. This is number 1. Because why this is coming today, your lordship may ask me that since you have made him party, why this question is coming? Because after 13 years. The reason is that because after 13 years, if he filed the written statement as on that day, the question does not arise at all. I am suffering last 15 years. 2010, I have filed the application. Today we are on 2025. All through, he followed the procedure. He taken the time, and thereafter, on the last occasion when he has sent that the matter is fixed for argument and expertise for the respondent number 1, he filed to put a petition and this application. Kindly see the grounds. These grounds, it cannot be.
Whether he is supporting your case or he is opposing your case. That is also a question.
He may support my case, he may not support my case. The question is, two things. One is whether, he can be allowed at this stage to file the written statement or not, considering the grounds taken in his petition. Considering the grounds he has taken in his petition. Number 1. And number 2, since the primary relief we have sought for against the 11 and 12, his application, to allow his application after 13 years will be a futile exercise of the power of this court. Kindly consider this aspect, my lord. Kindly, first of all, my lord.
Anyway, we continue on the next day.
And my lord, your lordship knows, my lord, the provision of CPC last on the next day, my lord, I will.
Yes, record an order.
On the next day, my lord, we will.
Learned advocate for the petitioner submits but could not conclude his submissions. Let this matter appear on.
Lord, if your service file be kept with the record. Since my lord, in the earlier occasion,
Let this matter appear on 18/7/2025 for further hearing. The affidavit of service file be kept with the record. না না ওটা তো হ্যাঁ মেন ম্যাটারটা হ্যাঁ সেটা বেঞ্চে যার ডিটারমিনেশন আছে তার কাছেই হবে
your lordship is
হ্যাঁ হ্যাঁ ওটা তো অর্ডার সবই তো অর্ডার করে দিলাম তো সবই তো বলে দিলাম
your lordship is taking the matter on 18th July
18th
at 4 p.m.
No, 18th is a Friday. Usually,
Oh, Friday, yes.
Friday. In the usual way, it is 2 p.m.
2 p.m. I'm grateful to your lordship. I'm grateful.
Not